Chairman Mills, welcome. We're happy to have you here this morning. Certainly feel free to make whatever opening statement you'd like to give us sort of a backgrounder, big picture, 30,000 feet, look at the legislation. Let me just tell committee members, we're looking at the substitute LC 284542S as in Sam. That's what we'll be working off of, and then after whatever opening comments you'd like to make, Mr. Chairman, if you could walk us through the substitute, that'd be great. Then we'll open it up for questions from the committee, and we'll just go from there. So
Sure.
The floor is yours, and thank you for being here.
Thank you, Mr. Chairman, members
sir.
of the committee. Thank you for allowing me to present this bill. This bill actually came out of, I was traveling somewhere and actually met another legislator, I believe he's from Illinois, that actually had a lifetime carrying permit in his wallet. And it sounded like a rather novel idea, and I confess up front I am not well versed in gun legislation. This has been a learning curve for me, and I'm still on it, so I hope members will be patient with me. But initially I introduced a legislation that would do that, call for a lifetime permit. After beginning to study it, due to some of the national identity check system that we have in place nationwide, I learned that you couldn't do in Georgia a lifetime carrying permit, but that we could take the current system that we have and make it a little bit easier to re-enlist. Right now I think the permit lasts for 5 years, and so basically the substitute, as I had it redrafted, what we did was we went back and in a nutshell we kept the fees the same. The basic changes are this, that the probate judge would now have to be proactive in notifying the gun carrying, the person who had the carrying permit would have to notify them from the probate judge saying, hey, and that's found on page 2, line 36 or so. That information is there. I think it's 45 days prior to the expiration. They would receive notification in the mail. Now, my initial thought to that, of course, is, well, that's a cost involved. So we kept the fee the same. They pay $15 now if they want to re-enlist anyway every 5 years. And so basically all this would do is keep them from having to come back in, get re-fingerprinted. They've already been fingerprinted once anyway. Why don't we need their fingerprint again? And I was trying to look for a way to make it more consumer friendly. And so I said, okay, the check is still important, I think, every 5 years, due to it's just a good check on someone's background, make sure nothing's changed. I think it's a good time to check. Sometimes people's health issues change within the course of 5 years, so that 5-year check would still be there. It would just be a whole lot more consumer friendly to the person reapplying for the card. And all throughout the bill you'll see where it has the language or renewal license has been stricken, and that's basically because what we're going to is they could just pretty well do it by mail and not have to go back in, be re-fingerprinted. The other change that we make in the bill is on the back of the bill, and let me find it here. It's on page 7, line 217. And it just says, licenses issued to such former law enforcement officers shall be distinctive in design by the use of color or style or other means from other license issued under this code section. And the summary of that is, if you meet the qualifications of the previous language to the language that I just read, in other words, licenses for former law enforcement officers, then they could print it in red or green or whatever color they wanted to come up with, so that when someone showed that card, they would immediately know, hey, this is a former law officer. That's actually just came as a suggestion from the constituent, so that's not anything I'm married to or wed to, but I did think it was a nice token to our law enforcement who do a lot for us all the time. And Mr. Chairman, I'll be happy to try to answer any questions, and again, I want to confess to the committee up front that this has been a learning curve for me. I've still got a lot to learn in this area of legislation, but if there was any way that we could, my original idea was to make it more consumer friendly and cost friendly. And so with the substitute, we've really not done anything to the cost due to the fact that we're making the probate judge be proactive by mailing that out. And I think that would cover that very minimal cost, but that's up to the committee's discretion. And if the committee so desired to drop it a little more the second time they re-enlisted, that would be up to the committee. Or I'm here to help me perfect this bill.
Thank you, Mr. Chairman. Appreciate your description here. Just for benefit of the members of the committee, this substitute came to us late, which is fine. Late last week, the vast majority of us have not had the benefit of the ability to go ahead and review it, so I think we're listening and reading at the same time. A couple of general questions. I see this more as an administrative type bill more than anything else. Right now, we have a situation where if you've got the permit, there are conditions that occur whereby you forfeit such permit. If a permit holder commits certain actions, they lose that permit, correct?
That's correct.
Okay. My general question is, and it may just be right in front of me and I just haven't seen it as I've been looking at it, my assumption is that there's nothing about that that's in those conditions still apply with this legislation.
That is entirely correct. We've not changed one word in the law in regards to that. The only thing we're doing is making it a little easier for the consumer.
In terms of, I guess, identification, I'm just sort of walking through it as I speak to you. Got the permit, let's say 40 years pass, 50 years pass. Is there a concern about the ability to identify that person a generation ahead in terms of who they are? I mean, we all look differently. I realize the fingerprint's the fingerprint. Any concerns about that you would enunciate in terms of our ability to verify this person is that who they're supposed to be from a permit of 40 years ago?
Well, I think all those can be done right now. I mean, again, we're not changing it. That would be the current situation,
right? If
there were a problem. But there's so many cross checks.
Can you talk to us about the cross checks
that a law officer can do now? He can check it against a person's driver's license. He can check their social security number. There are a number of things to make sure you are who you say you are. But a gun carrying permit now, I mean, that's a nice little fingerprint image that they've got on there. But I've always sort of looked at that and laughed. I mean, how would you be able to look at that fingerprint on a card and tell a difference between my fingerprint and your fingerprint? And it doesn't really identify anyone. Thank you. This is actually one. If the members would like to pass it around to see, is it okay? Sure. Thank you. And it's it's just kind of ludicrous to think that somebody can be identified on the side of the road by that fingerprint. Now, it's great to have it on record, and I think we ought to have it on record, and there ought to be files in place to make sure we can verify their identity, but that was the whole point.
I mean, it's cross-checked against an existing form of accepted ID.
Yes, and they've already made an application. They have to do a background check on them before they can ever get a permit. If they commit a felony, then they can't. They lose the right to carry.
We got all types of permits being passed around now. I believe this one was the one that came to you.
I think that's a Sam's card.
And a farmer from North Carolina actually has one. I'm proud of having one.
Let me know when you see a credit card go by.
Mr. Levitas.
Mr. Chairman, thank you for bringing this bill. I want to make sure that I'll understand. Originally, this was going to be a permanent license, and we're not doing that anymore. Is that correct?
That's correct. I'm told by the Legislative Council that we can't do a permanent license in Georgia and be in compliance with the Brady Act and the National Identity check system. I would love that. That's where I wanted to go.
Okay. A follow-up question, if I may, Mr. Chairman. I like the provision where it mandates that the return must be on the criminal background check must be within 30 days. But what I don't see here, because we can't obviously mandate anything from the FBI, I guess what I would like to see is whether you would consider a friendly amendment requiring the probate court to issue the license within that 30 after that 30 day has expired, regardless of whether the FBI check is back or not.
You mean before they're cleared?
Before they're cleared, if the FBI is not willing or able to comply within 30 days, I don't want to see folks who would otherwise be lawful permit holders prevented from getting their permit merely because the FBI has been too slow for whatever reason. There may be legitimate reasons, but if we're going to set 30 days as the standard, it seems to me that certainly we have jurisdiction over the GBI to mandate return within 30 days. We don't have that jurisdiction over the FBI, and I guess I would say that if the FBI cannot return it within 30 days, that at least a provisional permit ought to be returned so that they are a lawful permit carrier unless and until the FBI shows some, I forget what the term of art is, something like a derogatory return. But that I just want to make sure, because I think your intent is to make this check happen within 30 days, and I want to make sure that if it's no fault of the permit holder that there's been some kind of delay, that we give at least a provisional permit after that 30 days has expired, or, in other words, we treat a non-return the same way as a return. Because if the FBI doesn't return it within 30 days, it could be 6 months. And again, I think your intent is to speed up the process, isn't it? So that I don't know. I would guess I would defer to legislative counsel on that, but I would like to see that after 30 days, if the FBI, not the GCIC, because that's something we have jurisdiction over, if the FBI has not returned that criminal background check, that's not going to hold up the permit applicant from receiving a permit. Would that be? I assume that would be something in the nature of a friendly amendment.
Yeah, I don't think I would have a problem with that. Especially on a renewal. I mean, they've already got their information in the database and done a background check on them once. The only thing we want to ensure is the integrity of the system, that as gun carrying permit folks are, they're law-abiding citizens, and I'm trying to make it less egregious for our law-abiding citizens.
Okay, and Mr. Chairman, in light of that, I would at the appropriate time have a amendment.
Mr. Franklin.
Thank you, Mr. Chairman. Chairman Mills, thank you for bringing this important legislation to us. I commend you for it. I've got a similar question to Representative Levitas in that of the original concept of the lifetime permit. If our esteemed legislative council says that we can't here in Georgia, I'm just wondering how Illinois is able to, since it's the same federal law. And did legislative council address that with you at all? Or?
That's a good question, and I'm a little bit unclear, frankly, on legislative council's response to me. But they assured me that we could not do this, and I questioned the same question that you had. Well, how can Illinois do it, and Georgia not do it? That makes no sense. And I wish we had somebody from legislative council here that could follow up on that.
I'm wondering if possibly, I don't know if Mr. Thomas or Mr. White will be signed up to speak, but maybe they could address that possibly.
At the appropriate time.
Thank you. Thank you.
Mr. Evers.
Thank you, Chairman. Chairman Mills, thank you so much for this legislation. My question is in regards to beginning on line 36. The judge of the probate court shall notify the license holder within 90 days before the expiration of the license. And once the license holder receives that notification, he or she has 45 days to respond prior to the expiration of this license. My question is, you and I both know we live in a mobile society. People are moving all the time, relocating What happens in the event that a license holder does not receive that notification, which further delays or decreases the 45-day notice for him to renew?
Well, I think that the onus would fall on the person applying for the permit. If they've not updated their address, then certainly the probate judge court would not be held liable for having an incorrect address because they're going on information that they were last given. However, the current situation puts the onus on the card holder, which he's got to be the one who remembers 5 years down the road to go renew. And so we think this is much more consumer friendly and it doesn't penalize anybody, but that's a very valid point.
Yeah, I agree with you. I just noticed that, and I wanted to point that out. For the onus is on the license holder to update his or her records to make sure that their correct mailing address is on file.
Well, and I'm sure we'll have some situations where people will not update, just like we do in every other notification process.
Okay. Thank you.
Mr. Bearden.
I want to say thank you to the author for bringing this, but when you sign legislative council, was a problem the reciprocity issue with a lifetime? We could do in the state, but those lifetime permits may not be able to meet the reciprocity issues in other states, correct?
Reciprocity was mentioned, and that was one of the reasons that was given, was that maybe this state has surrendered some of their reciprocity, but given a lifetime permit within just their state boundaries.
Just agree with Representative Franklin. Under our Constitution, it states that we have the right to bear arms, but we have the right to how they're born, so we would have that right to do one in Georgia. It would just be very difficult outside the state because we could lose that. So I just want to make sure if that was the issue, if it was something else they were talking about. So thank you for that.
Thank you. I mean, this is exactly why we're having this as a hearing only, because it was inevitable that issues like this were gonna come up, and that warrant additional vetting for us to get some clarity on. Certainly, the issue that Mr. Franklin and Mr. Bearden are bringing up, for us to get some clarity on why is that, and just for our fortification, we want to be. We want to make sure there are no inconsistencies as it applies to our laws here related to other states.
I agree entirely, Mr. Chairman, and I will say that I know that actually someone had sent me a possible amendment to maybe centralize things and to move them from the probate court judge to a central, either Secretary of State's office or even some other office. And I just wanted to, at least the committee, to know that I would be opposed to that at this stage in the game.
What's that?
From moving right now, all this information is kept by probate.
Sure. In
the probate offices locally. Mm-hmm. There's some folks who would like to move it to one central place, right, such as Secretary of State's office, and there may be, someone may offer an amendment along those lines. If they do, I would just ask that the major issues are going to be, number one, fiscal note, because you're going to have to set up a database and a central. And then I'm not sure of the climate among our constituency to move things from a local office to a statewide office.
I couldn't agree more. Our Secretary of State, Karen Handel, does a great job, but she's got her hands full. And I think moving anything from the local level to the state level would be what I would call anti-streamlining. Mr. Knox. He waves. Ms. Benfield.
Thank you. I just want to make sure I understand the reciprocity issue that Representative Bearden raised. I do know there's one state, is it Indiana, that has done away with or has established a lifetime concealed weapons permit, and there's 2 states, I believe, that have no renewals, no requirements. So there's some precedent out there for the reciprocity issue, and I didn't fully hear everything or understand everything Bearden was saying. So if you could just repeat some of the reciprocity concerns and how they've been addressed in this bill. And I have a few other questions.
Well, again, we're not changing any of the reciprocity issues in this bill, and that was the problem that Legislative Council told me I would run into if we did a lifetime permit initially, and thus the substitute that you have before you today. So basically what we did was we went back to just a renewal every 5 years, but they would not have to go back for a fingerprint permit under this situation. and it would make it easier on them, and plus it would put the burden on the probate judge to notify the card holder before it expired.
So a state like Indiana, Indiana permit holders could not go to another state and necessarily have their state license recognized. Is that correct, because of the reciprocity issue?
Well, again, I don't want to speak out of turn here. As I said earlier, this has been a learning curve for me, and I didn't clearly understand the response from Legislative Council, but they led me to believe that was the issue, and that was the case, that they could be forfeiting some of their reciprocity rights.
But simply doing away with the fingerprint requirement but still having a 5-year check would address the issue. That's your understanding?
Oh, you still have the fingerprint requirement.
Initially.
Yes,
initially. At the
right.
onset.
Right. But how many times do you need to take a fingerprint to have a fingerprint?
Well, that gets to my next question, if I may, Mr. Chairman. I know you and I, we've had many discussions on previous bills about false ID, and that's a real concern. And I certainly would have that issue here because I think the fingerprint is a check on false IDs. So I'm thinking of the scenario of what if the permit holder has moved. The probate judge, exercising their duty, sends the renewal form to the last known address, 5 years old. The person at that address is no longer the permit holder, but that person takes that renewal, fills it out as if they were the permit holder, and then the renewal is sent to them. There's no fingerprint check. There's no photo. How would you address that concern, or how would that scenario play out if this were to be enacted into law? How could you prevent that incident happening?
That's like trying to stop a suicide bomber. How do you stop somebody who's intent on committing fraud and signing documents and stating that that they've not committed a felony? There's a background check done on them. We're always going to have fraud to some degree.
Oh, I agree with you, but that's the fingerprint. I don't think the suicide bomber situation is a comparable situation. I mean, we do have a method in place right now for checking on the false IDs, and that's a fingerprint. And nobody else has a fingerprint just like mine or just like yours. So that would prevent the person who just happens to live at the same address from filling out a form. A related question I have is there in place, and I don't know this, with the probate courts of Georgia, a centralized database where if somebody has initially applied for their license to carry in Clayton County, then they move to South Georgia and they apply for a renewal in 5 years in Chatham County, prior to the probate judge in Clayton County having to go through that whole process of sending out the 5-year renewal letter, is there a way they can check, the probate judge in Clayton can do a database check and see that that person has already applied for a renewal in Chatham County and no longer resides in their jurisdiction, so they can kind of not have to, so they won't have to send that renewal letter? What's the status of a statewide database among the probate courts? Does such a thing exist? Are they communicating among jurisdictions?
I don't know, but we wouldn't be changing the process by which we're not changing any of that under this bill. But I don't know the current how that's cross.
But that would give a check on the system if James Mills with this Social Security number and this date of birth has applied for renewal in another jurisdiction, then the probate judge will know they don't have to go through the expense and the process of issuing a renewal letter because it's already been renewed. It just seems like there's a duplication of services here. I think there should be a database. And maybe the probate judges are here, I'm assuming.
They're here.
Okay.
And they'll justify.
All right, so we can hear from them.
Maybe they'll clean up some of my bad answers. I apologize.
I do have, is it okay? I have a couple more questions.
Let me ask you one more, then we can go around the horn a second time.
Okay. My next question is page 2, line 45. And this, it may be here somewhere else, and I just haven't checked, but you have for the renewal that the probate court will do a criminal history check, but Georgia law also requires a mental health check, or I don't know if it requires a check. I know that persons who've had an involuntary commitment in a mental health facility within the previous 5 years are ineligible for a license to carry. But I don't see in here, and I may be missing it, where there is some type of check required for the mental health background. And so I want an assurance that somebody who's had a commitment for a mental health illness, which is obviously a real public safety concern, is not going to be eligible for renewal. So how is that issue addressed?
I asked that same question to Legislative Counsel. I'm sorry I can't take you to the exact language. I'm looking for it as I speak. They assured me that that was addressed because that was one of the things I asked them to address in the substitute.
I mean, that's a real concern of mine, obviously. You don't want someone like the Virginia Tech incident. That's a person who had a recorded history of mental health illness. And so if there's a check in place, we can weed out those individuals who we don't want having a license to carry.
Well, I think we found a great point for you and I to agree on.
Well, there's a first for everything.
Mr. Knox. We agree on, the chair, I serve on his committee. We agree on a lot of issues. I have a great deal of respect for Mr. Mills.
Just a little Monday morning humor. I apologize. Mr. Knox.
I'm sorry, I'm looking at the next three lines below that,
53, 54, and 55, that says that the judge of the probate court, and maybe I don't get this either, but it looks to me like that one of the things the judge is supposed to do is get the criminal history check. Doesn't mean he's not supposed to get the mental health check, and that it says on 54, 55, 56, after receiving the results of the criminal history checks, the judge of probate court shall verify the eligibility of the license holder for a renewal license. I think eligibility includes more than the criminal history check. It includes all the other requirements that are already in the law in order to be eligible. Again, there's nothing in this bill that's changing the criteria for being eligible to have a license. It's just simply saying when you go through it, there's a different way of renewing it. That's all.
Mr. Chairman, Representative Knox is entirely correct, and on page 3 of the bill, line 91, that's section 4, Representatives. On page 3, line 91, that includes that whole mental hospital or inpatient language that you were referring to. And that's current law, and again, I haven't changed any of that. As you can see, it's not underlined, but so that is addressed.
I have one other question.
Yes, sir.
With respect to this issue of sending the application out to someone who it doesn't belong to, can you think of any way that you could possibly avoid doing that? I mean, that's something that's going to happen, isn't it? When you do, I think, a renewal of any kind of a license, and you send a notice to them at their last known address. If somebody decides to commit a criminal offense and take their application and fill it out, they're probably not going to get caught until somebody catches them. You know, it's just like any other crime. If you commit a crime, you get by with it until the law catches up with you, or until somebody discovers you at having committed the crime. That's all that's addressing is if you commit a criminal act, including taking someone else's property and converting it to your own use, that's a number of different offenses. And no matter what kind of a system you have, you're not going to be able to keep people from doing that. I mean, I could go and steal it out of your wallet, even without regard to a renewal, and send it in and ask for a renewal, whether it came to my house or didn't come to my house. So there's not really any way to avoid that except to have maybe some kind of a central system that's going to be big. The big eye in the sky to look and see who's got a license and make sure everybody's got a license, supposed to have a license, and yada, 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 on, and have everybody register their guns, I guess.
Well, they would be committing a crime to fraudulently fill those documents out. We know from the last election, the Secretary of State has gotten in over 4,700 questionable registration ballots, which they've sent out over 2,000. They've got over 2,000 to respond to those questionable registration ballots, and over 2,000 have yet to respond. So, we've had voting registration in place for a while now in Georgia, and you still got fraud going on. And I'd assume you're going to have a certain amount of it in every area.
In the scheme of things, if I may, Mr. Chairman.
Yes, sir.
In the scheme of things, it's more important not to have fraudulent votes than it is not to have fraudulent carry permits. Would you agree?
I agree.
Mr. Setzler.
Thank you, Mr. Chairman. Chairman Mills, appreciate your being here today. When we talk about fundamental rights, this is something that obviously we need to spend a lot of time with, and I appreciate your willingness to discuss this with the committee. I'm reminded, government secures and protects rights. We permit privileges, and I'm hesitant, and I don't want this General Assembly to overregulate this process, and that's why I've got some concerns to make sure that the notion of trying to protect a lifetime permit while still maintaining reciprocity with other states, if it's something we can achieve, that we do achieve it. And my questions are really centered towards that. And what I would ask you is, if the concern with a lifetime concealed carry permit is one of reciprocity, does it require that we re-permit every 5 years? Or could there be a process within the sort of regimen of a lifetime permit that the courts simply check every 5 years? To do a check against a crime database, to do a check to make sure an address hasn't changed, invisible to the permit holders. The permit holder moves on with their life and is able to continue to use their firearm and as they had, but there's still a way that every 5 years the probate courts go through the same process of going out and doing it, whether it's a GCIC check or whatever the crime databases are that they check against. That check happens, but unless there's a hit or they find that the crime's been committed, the person's able to move forward as a lifetime permit holder. Because it would seem, if that's the case, we could still meet the core requirements of these reciprocity issues with states that don't require that don't allow for a lifetime permit. I mean, the substantive checking every 5 years could still be maintained without a permit holder having to go through this permitting process every 5 years. Would you have any thoughts about that?
Well, naturally, we wanted a lifetime permit. This is the drop back punt where we find ourselves, and I'm not opposed to the things that you mentioned there. I do think the 5-year check is important.
Sure.
In the process, I'm not sure if what you suggested would cause reciprocity issues or not.
Because I think it's somewhat consistent with what Representative Levitas said. He didn't want there to be this, after 5 years, this sort of inference against you that you've got to prove yourself again to get your permit, but that the process could kind of keep the momentum. And I think if we could frame this perhaps in a way that there is a lifetime permit, but the probate courts go through the same process of checking against the criminal databases as they would if there was a full permitting process again, but that the permit continues and the probate courts would simply stop it. They'd stop the music. If they found something funny in someone's record, then I think we can have the best of both worlds. So, since this is just a hearing today, Mr. Chairman, I would suggest this as a consideration.
Let me make sure I've got clarity on this, and then Ms. Benfield again. What I'm hearing from Mr. Setzler that I think that there's some intrigue about is the ability for an individual to secure a permit, and it is essentially if I'm hearing the gentleman correctly, a conditional lifetime permit that, barring certain acts, circumstances, Ms. Benfield's concern and a well-placed concern about mental health stability, barring any of those conditions, that the presumption is the lifetime permit, barring some circumstance in which case that doesn't occur, and that the real issue then becomes the administrative one, what I think I touched on before about all the what-if scenarios that you desperately try to go ahead and plow through, and you think you've got them all, then you don't. I think that's what I'm hearing. Was that particular specific fact scenario, was that what was ruled out by Legislative Council, or was it? Can you illuminate that?
Representative Setzler's idea was never discussed. It's
Okay.
an intriguing idea. I'm hearing it for the first time. I did not have that discussion with Legislative Council. And again, if we're the whole effort here was to be consumer friendly while protecting very strongly our right to bear arms and constitutional rights. That's the source from which it originated with me. And on page 3 also, it's good review for us. It's current language. I'm not changing any of that, but line 77 through 90, again, give that background check that's done and important information that we'll want to make sure stays intact.
Did you have any follow-up, Mr. Setzler?
I have one quick follow-up.
Okay.
I think I share the same concern of all members of the committee that we've got. I think to protect the rights of existing permit holders, we not issue permits to folks who shouldn't be getting permits. Because one thing that I'm confident in, as I spend time in the district or we spend time here on the floor, is that permit holders are law-abiding citizens, and that's one of the powers of our system, is that law-abiding citizens don't commit crimes with firearms. And I think it's the folks that would assault those fundamental Second Amendment rights who would suggest otherwise. So I think we need to be very careful as we, consider this mental health provision that some provisions be there. I guess my question to you was: are there any examples, and this might be better addressed to other advocates? Is the existing language the best language? Is the inpatient standard the best standard? Or are we excluding some folks who might have been an inpatient for some thing that has nothing to do with their danger carrying a firearm that might be excluded from this? I raised that as a question. I don't know that, as we're opening up this code section, there's a more appropriate way to address keeping folks who are mentally unstable from having a permit to carry without excluding people who ought to have a permit to carry but can't because they admitted themselves for, after, I don't know. It's just, some set of conditions that we would not consider dangerous. I raise it to you. I've not considered that issue before, but I would ask the committee perhaps to consider it if there's a more appropriate way to address it.
I would suggest that we need to step carefully in terms of altering the existing standards by which the permit is allowed or not in the context of the mental health area. I think we potentially, just thinking out loud, I think we potentially open a Pandora's box of problems.
And I'm not suggesting we deal lightly. I'm just asking the question: if there's been problems there, is it sufficiently protective? Is it sufficiently inclusive? And maybe we ought not touch it.
That's a great question, I think, for the probate court when they have their time. Thank you for bringing that up.
Mr. Chairman, I would prefer, as you, I think that's pretty good language on page 3. If somebody checks himself into a mental hospital or gets checked in, I'm not comfortable with them carrying around a permit myself.
And I don't think Mr. Setzler is suggesting any widening, but it's just something for us to go ahead and check. It's a great question for the probate court. Mr. Collins.
I want to follow up on Mr. Setzler's question, and not hearing completely with a head cold, but I want to, when you talked about doing this to my, and Mr. Mills had talked about it as well, Chair Mills, about the courts doing this sort of as a behind the curtain, so to speak. Are you including the mental health there? And if so, how would that play out? Because with the mental health, that's a self-report, and then you get into HIP, but you get on a lot of other issues right there. So in essence, maybe just stop there. How would you address not just a GCI background check, but a mental health check as well?
Never considered. I'm not.
I mean, I'm not opposed. I just asking what would be a logical.
And Representative Collins, this is not a framework I came in today to propose. I'm not. I don't have a substitute bill.
Okay.
It's something I'm offering as we hear the testimony, that perhaps if the permit holder could move through with a lifetime permit, we have checks in place that allow each of those touch points to be connected with. That might be the best of both worlds.
And that's why I was looking, because these are checkpoints that have to be checked. And that's, Ms. Mills, just if that's a thought that we're going to run, we need to have that as part of the run process.
Mr. Chairman, if I may, I know on the banking committee sometimes we do a novel thing and actually read the bills. And on page 3, line 91, it might be good for us I'm just going to, not to be elementary, but there is some language that's addressing what we're talking about. And any individual who has been hospitalized as an inpatient in any mental hospital or alcohol or drug treatment center within the last 5 years of the date of his or her application. And here's Representative Collins. The probate judge may require any applicant to sign a waiver authorizing any mental hospital or treatment center to inform the judge whether or not the applicant has been an inpatient in any facility in the last 5 years, and authorizing superintendent of such facility to make the judge a recommendation regarding whether a license to carry a pistol or revolver should be issued. So I'm not changing any of that current language.
And I understand that, Ms. Mills, it also, Chairman, is understanding, but also in reading the language here, if I do say I was 5 years previous before getting the initial application, again, I was addressing more of what Representative Sessler brought up in this sort of pass-through in the back end. Well, after that initial one, I could have gotten the waiver signed off to start with for my initial application, but 5 years down the road, are we still classifying that as the initial application, or are we saying 5 years in as another application? I mean, that's, and if we're doing it without the gun owner's knowledge, basically, and the way I was hearing this, is my question is, so I mean, I actually, in reading the actual language in the bill, says to me that leaves still a gaping area right there, that after the initial application is processed, the gun owner himself would not be a part of this process. It would be again, and we're off a little bit here, but if it's something to be considered, it was just a question I had from the background on the probate side.
And that's exactly what we'll go ahead and pose with the probate court, and frankly, that's exactly what we'll take a look at when we tighten it up and mark up. So, Mr. Lunsford.
Thank you, Mr. Chairman. Actually, I'm intimately familiar with this code section. If you recall, about 3 or 4 years ago, I was the one that rewrote it to put us back in compliance with ATFs for the concealed weapons carry permits. And I have some questions. I'm not against what Mr. Mills is doing at all. I just do have some concerns. Mr. Chairman, is anybody from the GBI here today?
Mr. Bankhead is here, and he's free to be on the hot seat at his discretion.
At his discretion?
He's not on the list, but it's early. Oh, he is. Look, the last one. How about that?
Well, I understand where Mr. Mills is trying to go, and I want to help him get there, but I have some concerns. And when we rewrote this code section last time, I believe we had 14 rewrites from the ATF and the GBI before we ever got a piece of legislation that would satisfy the federal requirements, so that you could actually cross state lines with your concealed weapons permit and it be valid from Georgia, which also allowed us then to purchase guns without a background check as long as you had your concealed weapons permit. And I want to make sure, is there any part of this, and I apologize for being late, Mr. Chairman, I had to go to the doctor this morning, but is there any part of this bill, Mr. Bankhead, that you've looked at that will invalidate portions of what we've worked on in the past?
My recommendation would be to give a copy, like you did, to ATF. Let them review it, because that's what we had to go through with your efforts numerous times. I know it was frustrating for you.
That was an understatement.
But what this boils down to is whether or not ATF and NICS will honor the permit to buy a gun without a background check. And if they don't approve it, then every time a gun permit holder in Georgia buys a gun, he has to go through the instant check. And I think that might be the issue with the state connection, where it didn't get approved. So that's the issue at hand from our standpoint. But ATF, I would recommend legislative council. We have a contact at GCIC, an attorney that handles that. We're not involved in this anymore, but they run this legislation through ATF, like Mr. Lunsford had to do 14 months.
Mr. Chairman.
And this all applies to the reciprocity, I would assume, and to the ability to forego a background check.
Mr. Chairman, if I can follow up.
Sure.
And like I said, I'd like to help Mr. Mills get where he's going. I just understand this. It's a tough process. And by the way, ATF during the process will give it to you as clear as mud. Okay? And they will rewrite their own paragraphs 3 or 4 times because they changed their mind on the placement of a comma or period or something. It's an amazing process. They must be paid by the word. But with that being said, the concern I had when I read through it was where we instructed the probate judge that she shall issue the license and she shall order the FBI background check, and it's going to happen in a certain period of time. It's a little difficult for us to order a federal agency to perform during a certain period of time. unless that time frame is within the reason in which they're currently operating. I fully support what you're doing. Don't have a problem with that. Would love to help you try to get it done. But I can tell you it's about it's a goat rope in dealing with them, trying to get them to sign off on everything. But if you get it signed off on, you're good to go. Because currently, and the reason we had to change our previous laws, as many of you may remember, the federal laws had changed, so our concealed weapons permit was only valid in the state of Georgia, which was ironic because someone who wasn't entitled to purchase a firearm, own a firearm under federal law, could actually carry it concealed in the state of Georgia because we hadn't updated our laws. And so you could actually be convicted of domestic violence but could still carry concealed weapons but weren't allowed to even buy one. And it was a little bit weird. And so once we fixed that, we fell totally in compliance with the other states, so then they would then honor our concealed weapons permit state to state. And that was what we were trying to accomplish, so you could still go, you could drive from Georgia to North Carolina with a concealed weapon and still carry it without being in violation of their state laws, because we were all reading off the same page. But I would love to let council to work with Representative Mills if they could, and with Mr. Bankhead, and find out who our contact and make them sign off on it. In which case they don't have a dog in the fight once they sign off on it, and you'll be in good shape. But if you don't, they will deny it simply from the fact that you didn't let them look at it. So,
thank you.
That's my entire Cliff Notes version.
Ms. Benfield.
Thank you, and I just had a sidebar conversation with Representative Lunsford, who's being very polite and said, ladies first, if you want to ask your question first. And I said, well, you may ask the same question and do it much better than I would. And I actually did have pretty much the same issue with, has ATF been given an opportunity to review this? And I specifically wanted to address it in the context of the issue that I raised with the potential for fraud. If there is a person who receives the renewal form and they reside at the address and the original license permit holder has moved, they complete that form, they get the license. At that point, under current Georgia law, because of the Georgia is exempted, ATF has ruled that we're exempted from the NICS Brady check from licensed handgun dealers. That person could then take that permit and receive a gun. And I know Representative Knox said we can't eliminate fraud altogether, but I do think as responsible policymakers, we can set laws that reduce the risk and be cautious about how we proceed with this. My concern is that the potential for fraud here could affect the ATF review, exempting us currently from from the NICS check. And also in the context of the Levitas Amendment, I think if that were to pass, that would really put us in jeopardy with ATF. I'm no expert on the gun laws, but I think that if the Levitas Amendment were to be included, that would be a significant issue with ATF.
Mr. Knox.
Mr. Chairman, I hope that we haven't come to the point where we can't pass legislation in this state without first checking with some federal agency or bureaucracy or anybody else for the sovereign state of Georgia. And I guess if we do this wrong and they want to take our license as a state away from us, I guess they can do that now too. So my question would be, since this is only going to the issue of whether or not we can renew a license and on what, whether or not the license has to be renewed and on what basis it has to be renewed, and we've agreed that it's going to be renewed at some point. You're not changing that in the law. We're only saying that the process by which we'll renew it has to be, we want to change the process by which we've renewed it. Some people might not like the fact that we're doing that at all, but I think what I heard you say, correct me if I'm wrong, is that our legislative council has told us that using the process that you're recommending in this bill does not violate the federal law and would not result in us losing the reciprocity rights that we have under the policy, right?
That's how they've counseled me.
Okay. So then the next question would be, the only other question would be whether or not we want to pass that legislation that you're proposing to us that is in compliance with Georgia law, and to the extent we're able to tell that based on our legislative council's review, it doesn't violate or doesn't jeopardize the reciprocity agreement that we've been granted by the federal government for us to carry handguns somewhere else than in Georgia. Then I'm not sure I understand what the issue is with changing the bill. I'm not sure I understand what's wrong with us passing the bill as it currently exists without going through all these gyrations about getting there, going through the same thing we went through the last time, in other words, to get the legislation passed in the first place.
My sense is that Mr. Bankhead will have every opportunity to help to walk us through what that would be and why, and we'll count on him to educate us accordingly, and then we can make whatever decision we need to make according to the circumstances. I will tell you, I understand the frustration when it comes to that. By the same token, I would not want to see what will end up being a mountain of effort by Mr. Mills simply shot down by the federal government, then we have to start all over again. So it's a balance there, and we'll do whatever it is we have to do. This looks to me more and more like it's becoming a process, but that's what we signed up for. Mr. Everson.
Thank you, Mr. Chairman. In reference to Representative Benfield's concerns about fraud, a point of clarification for me, Chairman. On page 6, line 203, alteration or counterfeiting of license and the penalty for that, would that not be addressing her concern?
I'm sorry, I want to make sure I'm hearing.
Page 6, line 203, I think it's 203, my numbers are alteration or counterfeiting of license and the penalty for that. Would that not be addressing her concerns in regards to someone potentially? It's too broad.
It still doesn't.
That's current law.
Yeah.
Yeah.
This opens up, my interpretation, this opens up the potential for fraud. And this does not sufficiently address my concerns.
Okay.
We'll have the opportunity to address that later on when we get to a substitute that'll be ready for markup. Chairman Mills, thank you.
Thank you.
We appreciate
Mr.
it.
Chairman.
You're released on your own recognizance, or you're free to hang around if you'd like. That's up to you.
I do have another committee meeting that I have to go to, but I appreciate, as I shared with the chairman, I knew this would be a working process. I appreciate you just having a hearing on it. I'm hopeful that we can produce something that we can all agree on and support and make it more consumer friendly.
Just so you hear it from me, I mean, I think this is the type of thing that it is a process, to use your words, and but we're committed to a process that'll be productive, and we'll keep the ball moving forward, streamlining a process for consumers and for law-abiding citizens pursuant to the Second Amendment.
Thank you.
Thank you. Judge Brown. And Judge Brown, I see you're a probate court judge. I just don't know which jurisdiction.
I am the president of the Probate Judges Council for the state of Georgia.
And can you tell us what jurisdiction you're from?
Rockdale County.
Rockdale County. Thank you for being here. Look forward to your comments.
I am passing around a suggested proposal that we as the Probate Court Council has put together. There's a long history in this, and we have spent the last year working on this in areas that concern us as judges, that impact us as judges, and impact our constituents and your constituents back home. There are several things in the current bill that are gaps or concerns or problems that we are continuously running into, and what we have attempted to do and what I'm handing out is to clean up all of these gaps and problems to make this process a good process for us, good process for people who have problems with their permits, and not to make it any more onerous or difficult for people who are law-abiding citizens who do want to come in and get their permits. And that's where we're trying to balance all of this out. As far as what has been presented this morning, this is technically what we do now, except with the provision which requires us to send out notice. Many of us already send out a reminder notice out of courtesy to our constituents to remind them that their permits are coming up for renewal. Addressing her concern on fraud, what I do, and I can speak for myself and many of the other courts follow, not all of us do it, but many of us do it, is that we'll send out a little card. This is a reminder, your card is coming up for renewal on blah, 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 and it has a date. They then come in and initiate the renewal process. And by coming into the office, they then are before us, we see their ID, they sign off on their license, and I, in particular, give them the option, do you want me to mail you your permit, or do you want us to call you and you come back and pick it up, or we send you a reminder to pick it up? And I leave that option whether or not they want it mailed to them. I have great concerns sometimes when I mail out a permit. Is it going to get to the person it's intended to get to? And I've been in office 16 years, and I'm happy to report to you I've not had any notice of fraud on any of the permits. But I would not be telling you the truth if I didn't tell you that was an underlying concern. To my knowledge, I've not had any of the other judges share with me that that is a concern. Now, the involuntary renewal, where we ourselves take it upon ourselves to do a background check at the 5-year period, I don't think is proper, nor would we be allowed to do that. Because when we go in and do NICS checks, GCIC checks, and we request on mental health background checks, we have to have waivers from the parties authorizing us to do that. We're not allowed to go into a criminal background and do background checks unless we have waivers. And they have considered signing the application itself a waiver, but if they signed the application 5 years ago and we're now going in there for a renewal, we don't have a renewed application giving us the authority to go in and do a criminal background check through GCIC and NICS, because that is designed specifically for criminal background checks. And we have to have waivers in order to do that for a licensing process. The same, I think, would apply if we wanted mental health background information. We don't have waivers to require the mental health facilities to give us that information. With regard to mental health facilities and those concerns, in this particular legislation and what is going on now, there are several things that are happening. First of all, Georgia does not have a well-defined, clear database for mental health. They do for state hospitalizations. That is kept through the Department of Human Resources. And they've been in the process of passing that on to GCIC. And there are a lot of gaps in that. Private hospitals have not been required to make those reportings. And so there are some gaps in information on mental health background checks. We have the option of requesting from DHR the background checks. Well, they've reached a point that they can no longer process all the requests from 159 counties. So there are 11 counties right now that are seeking that information and running those mental health background checks. Some of the information has been passed on to GCIC, and our firearms application background is including those if they have it. All it tells us is whether or not they've been involuntarily hospitalized in a mental health hospital in the state of Georgia. And at that point, we can bring the party in, and we as the judge can inquire as to what that is and require them to bring information that we want to see. Under the federal guidelines, anyone with mental health background check was permanently prohibited up until 2 years ago. And now they're in the process of trying to decide how they're going to have or what guidelines they're going to set for restoration and what they're going to follow with regard to mental health guidelines. And they're in the process of doing that. Along with that, there is supposed to be some monies that are coming to states to allow us eventually to be able to set up mental health databases. So that's all, again, talking about federal government involvement and state involvement. All of that's going on in the background right now, and he can further tell you where we are at the state of Georgia. But that is the condition in which mental healths are right now. So we do make a good faith effort if we have knowledge of it within our county. For example, if someone has been declared incapacitated by the petition for appointment of a guardian or conservator, and we have knowledge of that, we take notice of that. So the mental health area is still an evolving area of which, again, we're at the mercy of where we get the information. You asked if there was a central database for the probate judges. No, ma'am, there is not. Under the old provision prior to this, there was a qualifier in here where if you transferred from one county, you moved from one county to the other, that you could come into the probate court and apply for a license as a transfer. And we could take that license based on the fact that it had been issued from a preceding county, do a NICS check, and if the NICS check came back clear, then we could issue a new license from my county. And that was taken out when House Bill 89 went into effect last year, and we no longer have the ability or the authority when we move from county to county to transfer our permits. That brings up another issue under Section 1611-128. If I move, let's say I live in Fulton County and I move to Rockdale County and I have a permit, and I'm asked to show my permit, under 138, if I don't have my current address on it, I can be in violation of carrying a firearm without a license, because it says it is to have my current address. Well, if I move, there's no provision for me to transfer my license to my new county. So in our proposal, we've tried to reconcile those kind of differences in the things that we've looked at and put together in our proposal. So I think we've created a void by not putting back in that you could transfer when you moved from county to county. You asked about the 30 days. There's a lot that's happened since we were in here a year ago. GCIC has now required that every probate court doing firearms must do a live scan, which has created some problems and has created some good things out of it. Many of us who are able to comply with it, when we do a live scan, that means the person who's being fingerprinted, it's electronically downloaded, the prints are done. You usually have the results back within a half hour. On a bad day, you might have them back within 24 hours, but the average turnaround time is less than 2 hours. We have the FBI, GCIC, and then it's transferred over, and there's a NICS and the GCIC run. Our ICE background is run if necessary. So the turnaround now on fingerprinting is running usually within 3 days, 4 days. We're going to have it back in our office from the initial fingerprinting. One of the things this current bill and the bill we're now under says is that I am, as the probate judge, am to instruct my sheriff to fingerprint them within 2 days. Well, the person who wants to be fingerprinted may not go out there in 2 days. They may decide that they can't do it this week and they don't go to next week. I don't fingerprint in my office. I don't have the equipment. I don't have the certification. I don't have the money's not been allocated to me to do that. So they have to go to my sheriff. We have 3 counties right now where the sheriffs are refusing to fingerprint the folks and saying that their secured area is not a proper place for the public to be coming in, and they're not fingerprinting and are refusing to fingerprint them. So they've had to turn and go to what we call a GAPS. GCIC has set up throughout the state private entities that have a live scan fingerprinting, and a person can go to that, and they're within 25 miles of each county. There's a GAPS location. In some areas, that's worked very efficiently. In some areas, it has not worked very efficiently. So again, that is a secondary backup to being able to get the live scan prints and to get them back to the court relatively quickly. We have found that it's working very well, except for people who are aged or people who do manual labor who have real difficult prints, and then the live scans don't always work. We have a provision to do a name check, but before we can do that, there has to be a denial process both at the federal level and at the state level before we can do the name checks. So we're working through that process, and it's improved the turnaround in the histories back to the probate courts significantly and made the job much faster. On the flip side of that, permits are up across the state of Georgia. And I said I've been in office for 16 years, and the average permits for my county have run between 900 and 950 per year consistently for the last 16 years. I issued 1,833 permits last year in Rockdale County, so it's on an increase, which means I've had to pull personnel to move these through in the 30-day requirements to get them out so that I'm not personally liable, that I'm doing the job that I've been instructed to do, and it is costing me and it's costing my county. Right now it's costing, and I figured this on an average, it is costing us approximately $47 to run a permit, and that's on someone who has no criminal background, who doesn't have to be pulled out. There doesn't have to be an additional process to get the information. So we're running right at $47 for the cost. Between what the Sheriff's Department gets for the fingerprinting and what I get for the permit, we're receiving $20, which means I'm $27 in the hole, and you can take that times 1,800 and figure out the deficit that occurred in my office last year. Now, that hurts me when I have to go to my county commissioner and say, I need this because, and they're going, well, why don't the fees go up? Well, I don't control the fees. But I think you need to be made aware of the cost is there. And I want things to be as efficient and as easy as I can for the consumer. And what we have just done, and it went in effect last week, so I cannot tell you how it's going to work, I have now put my application online. They can get the application, they can complete the application, and they can walk into my office with it finished. And when they walk in there, it should not take my staff, I'm hoping, no more than 8 to 10 minutes to put the information out and generate what they have to sign to proceed to get fingerprinted. And I'm hoping that will cut down on some of the time that it's taking in us processing the applications. We've also set up where they're going to have the dual option. If they want to go to a location, a GAP location, and get fingerprinted, they can take the application because they pay that GAP facility for that fingerprinting, so I don't have to collect a fee for them to do that. If they go to my sheriff's department, I am collecting the fee for the live scan that they have to get there. In the proposal that we have given you all for renewal, right now the renewal is that they have to come in and start the process all over each time. That's the way it's set up right now. So they have to come in, they have to be fingerprinted every time, and they have to continuously do that every 5 years. We have sat down with ATF and discussed with them, can we renew with a name check only? And they have verified that we can, and that is our proposal here, is that they would do a name check. It is probably still going to require that the applicant come in and sign off on the waivers and sign off on the permit, because on the permit it also has a signature of the person who's getting the permit. So that way we've verified who they are, looked at their ID, have some verification of what's going on. So they're still going to have to probably make a trip to the probate court, but we could narrow it down where they make one, and if they elect to have the permit mailed, we can mail it. So it's narrowed down to one trip.
Let me ask you a question about that, and I appreciate the presentation. It's educational for us. With regard to the signature and the waiver, to your knowledge, is there any preclusion upon a first application or upon a first renewal after such and such date of an effective date, frankly? Is there any problem with the applicant or renewal permit holder after a certain date upon their first renewal of signing a permanent waiver, so that we get to Representative Setzler's thought about having a conditional lifetime, which would preclude the necessity of them coming in every X amount of time, as you just stated? Is there anything, to your knowledge, that would preclude that, either in state or federal law?
I don't think there's anything that precludes it as long as it's current. I don't think a 5-year a waiver they give me now is going to be valid in 5 years. Now, if they wanted...
Let me ask you, if they go ahead and sign that waiver at that time with the understanding and with the proper language that this is a permanent waiver to be in effect 5 years from now, 10 years from now, 15 years from now, and down the line, if they sign that waiver with that language in there, why not?
As far as the GCIC criminal background, you'll have to address that with them.
Okay.
Because they know what their requirements are, and I know what the procedures are. We have to have verification each time that's run, how we maintain those records. We have to be able to audit how we're doing those records. So if I'm looking at a 5-year waiver, are they going to be happy with it? That will be their call.
Okay.
As far as medical records and mental health records, you just about have to have a waiver each time that you want to proceed with that, and that waiver has to go directly to them. So I don't know if you signed a waiver 5 years now, they're going to honor that 5 years later.
Well, that's the same issue. To me, that's the same issue of, can you go ahead and essentially create a permanent waiver whereby the permit holder agrees that every so often the probate court's going to check for X and Y, and if there's a problem with X and Y, then it'll be addressed. But in the absence of...
If that can be done, I don't have a problem with that.
If I could just finish. In the absence of that particular problem, then the permit extends on seamlessly. One other question, just for clarity, for my own sake and for members of the committee. Right now, when a permit application comes into probate court X, what is state law with regard to how fast, or what is the time frame by which the probate court must go ahead and issue that permit, barring any problems with the application?
Right now, we have to issue it within 30 days unless there is something that prohibits them or potentially needs further investigation.
Okay.
So you have a time frame, and everything has to be file stamped in within 10 days, and it may be set out in here. I don't know. Obviously, as the judge, you can tell that I don't do it day to day, but there's a 10-day that we're required to review. Then within 30 days we have to have it sent out. And one of the problems that we are running into, and I was going to address that, is the mental healths are not coming back to us in the time. For those counties who are seeking the mental health information right now, that is the only thing that's taken us more than 30 days.
One other question, then I'll open it up. Is it your impression, you're the president of the Council of Probate Judges, is it your impression that the 159 counties, barring a problem with the application, is it your impression right now that there is conformity with the 30-day requirement amongst the 159 counties?
I think there's a great effort in that, and if we have one or two that are out of the time frame right now, it is simply because we're not being able to get the fingerprinting done. Either the sheriff is not cooperating, we don't have a gap site there, and all of this just generated in the last 90 days, because effective February 1, it started off effective January 1, and then February 1, everything had to go to live scan. So we do have some courts that are transitioning and trying to get the live scans done. But I would dare say out of 159, we've got 155 in compliance, other than those who are getting mental health background checks, and it is taking about 35 days for those to come back.
Thank you. Mr. Levitas.
Thank you, Mr. Chairman. And, ma'am, I appreciate your being here and providing us with this testimony about the difficulty that your court has in managing this. And I guess what I'm wondering is this: since we already have the Secretary of State responsible for so many different licensures and already has database and all those things available, and since it apparently is an economic it has an economic impact for you, wouldn't it be better if we just gave this particular authority over to the Secretary of State and allow them, like they do with other licensures, to go ahead and handle the permitting and just remove it from probate court altogether?
I don't believe so, and I don't believe the people of Georgia would want that. First of all, they'd have to deal with the state agency, so when they had questions or difficulty, they would not be able to do that at a local level. I think coordinating from the Secretary of State to the Sheriff's Department, which is somewhat of the draft that we've seen, I think would be very, very difficult to coordinate. I think most of our constituents appreciate the fact they can come to the local court and they can ask questions, they can seek the information they want, and they leave satisfied that they've obtained an answer and they've been able to handle it. I think the cost of setting up a specific office at the state level and creating the database sounds really good, and part of that's already in place, but it's not in place to meet these guidelines. We've also talked to ATF and to the NICS, and there is some concern that the Secretary of State would not be a criminal investigatory agency, and therefore would not be eligible to be a center or a central location for state licensing. So with all of that in there, and we were doing this last year as we were going through the Senate study committee and hearing, we contacted ATF to discuss some of that with them, and on the face of it, the Secretary of State's office would not comply. Now, not to say that they couldn't if certain steps were taken to meet ATF requirements and NICS requirements. They possibly could, but right now they don't.
May I follow up, Mr. Chairman? Sure. Now, of course, we as a legislative body can authorize them to be that criminal investigative entities, and I think you've identified that correctly. So we can make the legislative changes, and there may be some certain efficiencies to having it in a centralized manner. I also think if you're having trouble getting your sheriffs to comply, and I'm sure you're not the only jurisdiction, if there are both if it was coming from the state as opposed to a probate court, as well as if it followed certain sanctions for the failure to comply, wouldn't that, again, be more efficient? There's nothing that would prohibit probate courts from continuing to be a resource for local constituents to come, and in fact what that would do is expand the ability to provide information. You could provide it at local level, and there would also be a specific office at the state set up to deal with these problems, and rather than have anecdotally one particular county, they would be the central clearinghouse, and those questions and concerns would come up constantly, and then that would relieve you both of the financial burden as well as the administrative burden and give it to an entity that is really in the business of providing licenses, whereas, as you know, that's not a probate court's main function. So, again, I guess I'm having trouble understanding the resistance to release yourselves of that responsibility, since when you sat down here, the first things I heard you talk about were all the burdens that are imposed upon you, both financially and administratively. So is there any other reason that you would not want that to be at the state level besides what you've told us?
Well, I think the burdens that are upon us are going to be the same burdens that are on a state agency. Those burdens aren't going to go away. Those burdens are created by other agency requirements, federal requirements, the pros and cons of doing the permit. Those burdens are not going to go away. You're still going to have the same problems at the Secretary of State level that you have at the probate court level. Because if the at the Secretary of State level, and if the direction is you go to your local sheriff to get fingerprinted, and the sheriff doesn't want to do it or doesn't feel comfortable in letting the public come in, Secretary of State's still going to have that same problem. And if the Secretary of State's here in Atlanta and the sheriff down in South Georgia, you're probably not going to have the communication that goes forth with the probate judge and goes sits down and they finally work out their differences, whatever they may be. And when that person down in South Georgia wants to know why their permit's not being issued, or what is the process, or what's being held up, or they've gotten some notice that they have to comply with this, this, and this, and mail it to the Secretary of State's office, I don't think they're going to be really happy with that. I don't think they're going to feel comfortable with that. They're going to feel like we've taken it away from where they could go sit down and talk to someone and discover what's going on, versus somewhere outside of where they live and the people that they know. So I just don't think it's a good practice. I think at least this way we're serving the people. We're getting information to them. We're working to make sure that the application process is as smooth as we can for them. And when not, we're able to sit down and explain to them what's going on, and they understand it.
Mr. Chairman, if I may be permitted, one more question. I guess, again, I'm trying to figure out why you would not be able to do that, even if the administrative process was at the state level. Why would a probate court be prevented from providing the information, attempting to facilitate those contacts? And I agree with you that the same burdens that are at the state level would be at the probate court, but instead of having 159 different probate courts all trying to figure out what the right answer is, you'd have one central office, and when that was resolved, whatever the confusion was or whatever the approval process is, you'd have one central office that was approved for that, and you wouldn't have to be reinventing the wheel every time. My guess is, without knowing your county, what your constituency is interested in is a streamlined process that will get them the permit as quickly as possible, and whether that's at a local level or whether they have to put a 42-cent stamp on an application and mail it up to the Secretary of State's office, their interest is in how can I quickly and efficiently get my permit and not have to worry about a tug-of-war between a local sheriff and a probate court, because you've already told me that you have sheriffs that are refusing to do the permitting. And I would suggest to you that the state of Georgia may carry a little bit more authority than an individual probate court in terms of getting a sheriff who is refusing to comply with the law to comply with the law. And I just want you to think about, again, whether if ultimately our goal is to serve the constituents faster and most efficiently, that whether that's at the state level of the probate court, we all ought to be on the same page for providing that service as quickly and as efficiently to the citizens of Georgia so they can carry out not only their Second Amendment rights under the Constitution, but as important, if not more important, their rights under the Georgia Constitution to bear arms.
Well, I think what you've said you can do whether it stays at the probate level or at the Secretary of State's level. Because if making sheriffs compliant with fingerprinting is what we're talking about, then you have the ability to do that. Whether it's out of my office, they get the application, or out of the Secretary of State's office, they get it. As far as decisions and what is or isn't in compliance, I feel that the probate judges have a pretty consistent policy of what is compliant and what isn't compliant. And other than having to wait on reports or making sure certain information is gathered in a timely manner, that is what we're struggling with. And I think any agency is going to struggle with that, whether it's the Secretary of State or the probate court, because it's coming from different agencies, it's coming from different levels, and we're dependent on other people to do certain things to get them back to us in order for us to do what we have been legislatively directed to do.
Mr. Bearden.
Yes, ma'am. Can you tell me how many other states in the nation allow probate court judges to handle licensing?
We're the only court left.
So 49 other states handle it just fine without the probate court judges.
Well, actually, there is one other that's kind of quasi-court, and I'm sorry I can't tell you what state, but there is some process that goes through the court, but none. And we're not opposed. We just want you all to understand that if you take it from us, what we have suggested in our proposal is in fact still going to apply to whoever it is, whether it's Secretary of State, the DPS, whether it's GBI, whoever does it.
But it would relieve a workload and possibly thousands of dollars that the county's not getting.
Well, the county's not getting it, nor is the state going to get it.
But we're talking right now on the local level, though.
Well,
you're
I'm telling you, the state's not going to get it.
But you're referring to $25 per permit over 1,800 permits that you're losing, correct? So
well, I said yes, I am losing $27.
I assure you, warm my heart when you tell me the permits are on the rise in this state. That makes me feel great for what's going on in this world right now and socialism around the corner. So, how long has a probate court judge been issuing a license in Georgia?
Well, I've been in there for 16 years, so I know they've been issuing them for 16 years.
It's been longer than that, I can promise you.
It has. It's been forever, since almost the beginning of time.
But there's just a stigma in the past that occurred back from the Atlanta race riots that when all this took place, I think needs to be erased from our state books. But I do appreciate you answering the questions. Appreciate your time.
And I want to say, Representative Bearden, first of all, I am a gun-carrying person myself, and I do not want the federal government telling me what I can and can't do. But I do know that we have, for years, we have looked at the gun laws, and we've never been able to sit down legislatively and put together a good bill that would allow people to do what we do and to make sure that they can carry their guns. But for those who are committed offenses who should not be carrying guns, this is not a very good bill that we have right now, because there are people out there who have criminal records who are getting firearms permits and probably should not be carrying firearms, or at least for restricted periods of time. And it is a very convoluted bill that is not well put together, has not been well thought out or put together from the entire legislative session or legislature for the state of Georgia. And I would commend you to look at this to see, and we're more than willing to sit down and talk about it, because again, the problems that we've tried to address in our proposal to you all is those things that we see as judges that are causing problems, and would clear some of those up and probably help move many permits through much, much quicker. We don't want to prohibit someone who ought to be carrying a gun and can carry a gun to be able to do that.
Let me just follow up on one thing that she said.
Yeah, one last follow-up.
And you're right, there's people that should not be carrying firearms. There's criminals out there that should not have them. And we got to be very cautious that we do not violate or prohibit someone else's, the law-abiding citizens' rights.
Absolutely.
Or hurt them because of the actions of the unlaw-abiding. So we need to make sure that the citizens out there have every right to defend themselves. So I agree with you on that. So thank you so much, Mr. Chairman.
Mr. Knox.
I just had a question. The records that you get from the Department of Human Resources with respect to individuals who've been treated some way or other for mental health, are those kept then as a permanent file in the probate court, or what happens to those records?
No, well, I do not get the records per se from DHR. What I get from DHR is a verification that they have been hospitalized involuntarily within the last 5 years. At that point, I notify the applicant and have them come in, and I'll tell them, I need, because you've been hospitalized, and I verify that it is the person, verify that it has happened. Then I'll say, you are going to have to bring to me these certain records in order for me to make a determination whether or not you're eligible for a firearms permit. And then it's their burden to bring that back to the court.
Does it make any difference whether it was in Georgia or some other place?
Well, all I can get right now are records for Georgia.
So all you get is records for Georgia. They could have been loony as a tune someplace else.
They could have been in the hospital for 5 years in Texas, and I might not know it.
Okay. So we're subjecting Georgia's citizens to a different standard than we are somebody that moves here from another state.
At the federal level, those people who are attempting to come in and be in compliance with U.S. 18, which is the NICS check and those kind of things, the Brady Bill, all of that, many of the states are starting to put together mental health databases. But many of them are very similar to what we're in. They're in the process, and they've not completed it, or they're on the first leg. Some are further along than others. It just depends on how well the state has funded it or not funded it.
In your court, if someone applies and is declined, they're entitled to a hearing on that on the declination of the application in probate court then?
Correct. If they do not bring what the court needs to see, and normally when I have someone who is potentially not eligible for a firearms permit, I will hold the application in abeyance for 90 days for them to bring to the court what the court needs to see to complete and further its investigation. If they don't bring it to me, then I deny the application and tell them that they'll have to reapply.
But are they entitled then to a hearing based on your decline or?
In my court, yes, sir. Under the current statute, there's no clear provision for that. Under what we've proposed, we've set out where there would actually be a provision where they could either ask for a hearing or the court could automatically give it to them. I automatically give them a hearing on a denial.
Thank you.
Ms. Benfield.
Thank you. I want to follow up on some of those issues raised by Representative Knox. If the person, the applicant, has been committed involuntarily in a mental health hospital within the previous 5 years, and the probate judge reviews their record, I guess my question is that a per se bar? Can the probate judge review the records and then determine that even though they have had an involuntary commitment, they are fit and competent to have a license? You have that discretion.
Yes, ma'am.
Because it was the law is the way I read the current law. It's an outright prohibition initially, and then later I see the discretionary language. So it's difficult to interpret the way it's written here.
And it is, because that is very vague, but I can tell you our policy is that anytime there's a mental health, all of us, and it is consistent across the state, those who are doing the mental health background reports, that they come in and they have to show the court all the information the court seeks, and they have to have a letter from a current doctor or psychiatrist or psychotherapist stating what they feel as to that person's ability to have a firearm. And then it's left up to the judge whether or not they grant or deny.
And is there any access to private hospitalization records?
Not unless it's made known to us. And right now there's not consistency in how that's being reported. There are some new provisions where GCIC is supposed to be getting that. And again, I can't address how at what phase they are in putting that information in.
And with respect to the Secretary of State's office taking over this function, and I initially thought it makes a lot of sense as far as streamlining the process, but you made a statement that I want to pursue just a little further that was compelling for me on the mental health issue, in that as a probate judge, you do supervise incapacitated adults, you deal with guardianship issues, and you may have some of these individuals in your community who have mental health issues that are flagged by you because they come to your court for other reasons. So is that an additional check regarding the mental health issue that the probate judges are uniquely positioned to review, unlike a Secretary of State that wouldn't necessarily know the people at the local level?
And I think that is a practice all of us undergo, because we know the people who have come in for incapacitation or under us or through a guardianship. We also know what mental health issues and people that we've had to deal with on a local level. So there is a check within each of the counties of what's going on. Unfortunately, there's not a centralized database where that information is located. And only those counties that do involuntary inpatient hearings are required to report. So, for example, in my county,
Sure.
I don't have a hospital, so I don't do inpatient reporting. My adjoining county does that, not me. So, I don't have access to that other than what goes through DHR.
And to your knowledge, does the Secretary of State's office have any supervisory authority or checks on mental health commitments?
No.
And if I may, there's one more issue I wanted to pursue, and you keep referring to your proposal. I'm assuming this is when it was first distributed. I thought this was existing law, but this is a proposal that the probate judges has drafted.
Correct.
Is that correct?
We went through a Senate hearing process last year, and through that process, this is what we have developed and have suggested.
Well, I have a specific question with regards to your proposal for the renewal process. And it seems like it makes sense to me from what you've told me, is that the applicant for renewal would come in at least once. And your statement was that it could be an 8 to 10 minute process. At least in your court. I know you can't testify for all jurisdictions in the state. My question is, when that person comes in to sign the waivers and releases and complete the renewal form, is there a check on a photo ID to ensure that, if we remove the fingerprint requirement, would there still be some type of check by the probate judge to look at a photo ID to ensure, yes, this is in fact the same person?
Correct.
Yeah.
Even now on the applications, they have to show identification, and it has to have their current address, and normally it's a recognized identification. And so we do that automatically now.
But your proposal, the person, and under current law, the person comes in, you can physically view them, they hand you the license or the passport or the state ID, whatever, that's got a photograph, and you can
Correct.
verify, yes, this is in fact the same person.
Correct.
Okay.
Mr.
Thank
Lunsford.
you.
Thank you, Mr. Chairman. I wanted to clarify for my fellow committee members before they yell at me later. Because I complied with the federal law didn't mean I agreed with it 5 years ago, okay? But it was the only way we could get our permits back in compliance so we could move forward and make the changes that need to be changed. Judge, I've got a question for you. Do you find any of the restrictions on issuing permits to be a little bizarre? In other words, I'm looking through here under Chapter 13, Title 16, possession of one marijuana seed as a misdemeanor would prohibit you from having a gun permit for 5 years after your actual probation was over with. So it's lifetime. Okay, well, it's showing it here. It must be.
Well, in our proposal, there would only be a 5-year restriction. Right now, there's a lifetime restriction.
Yeah.
So if you have a misdemeanor marijuana, according to Attorney General's opinion in Georgia, you're prohibited from a firearms permit. But if you have committed armed robbery and you actually have gotten a full pardon,
And
it
served
allows
your
you
time or
to
pardon.
you then can have a permit. So in our proposal, we're trying to fix those things that are inequitable in the process that's currly in place.
Well, Judge, I appreciate it because I'm looking at
So
1613.
we absolutely agree with you.
Yeah, I'm looking at 1613-16, and if you had a joint in your car, you're for life prohibited, but you could have marijuana brownies, and the cake is excluded. And I've yet to figure that one out, Your Honor, as to why that would be. So I guess what we should tell everybody is to bake it into a brownie, and you'd be okay. Or the fact that if you sold modeling glue in your store and did not keep a record of it and were convicted as a misdemeanor of failing to keep accurate records of who bought model glue in your store, you're prohibited from carrying a concealed weapon. I'm not sure what basis. I don't know if that's for life or just 5 years after
And you'd have to look at how that charge.
5 years after your supervision has terminated. So if they put you on 10-year probation, for 15 years you couldn't carry a concealed weapon because you sold model glue and didn't keep a record of who bought it in your store.
You could possess a gun, you couldn't have a license to carry.
Correct. You couldn't carry it, and you would still have the store, I guess, unless you got robbed in the meantime. But you wouldn't be able to carry a concealed weapon, so you could be, I guess.
You could buy a gun. You
Right.
probably could have one in your business in your home, but you can't carry it concealed on your person.
I just find some of these prohibitions a little bizarre, to say the least.
And again, that's why we have tried to sit down and intelligently address the things that we have found of concern in this proposal.
Mr. Sessler.
And we're not married to it, but we're certainly open to changes or suggestions.
Mr. Sessler.
Thank
And
you,
then
Mr.
we'll wrap it up with the judge here.
Thank you, Mr. Chairman. I would just offer the committee to Representative Lunsford's concern that was not my principal question, Mr. Chairman, but I would submit that, and I would hope we would have the probate court judge's support in this, in providing some cleanup language to those kinds of things in whatever we do in this bill. Mr. Chairman, that would be a major intent of mine. To the witness, however, Mr. Chairman, I'm trying to understand, and I need to plead some ignorance here. I'm trying to understand, getting back this mental health provision that we have to be very careful about. You refer to involuntary referral to a mental facility, and as I'm reading in the current bill, LC version 4542, which I understood to be just a restating of the existing provisions, it says any individual who has been hospitalized as an inpatient, not dealing with involuntary referral, but just present as an inpatient under any circumstance, would be prohibited. What does the law say specifically with respect to the mental health patients?
All right. Inpatient can be someone who voluntarily commits themselves.
Yes.
And they may do so in a private facility.
Okay.
And under the current reporting guidelines, we're not getting all of the non-state hospital information. What we're getting are the involuntary inpatient commitments.
Okay.
So there is a gap in what is being reported and what is being maintained in the database.
So the current state of the law is that if you've ever been an inpatient, even though the probate court judge might not be able to get access to it through a database, when you sign your certification form, if you've been an inpatient, even if you referred yourself, you'd be prohibited from getting the permit.
Correct. But unfortunately, when folks sign those applications, they don't always tell us the truth. You know, I had one come in a month ago who signed that he'd never had a criminal history and never had a criminal record, never been arrested. I got his criminal history, and just 9 weeks prior to making the application, he was charged with murder in the adjoining county. I brought him in for a hearing to find out why he signed that. He says, well, I hadn't been indicted, I hadn't gone to jail, I made bond, so I didn't think it mattered. So people don't always tell us.
Is there a remedy for someone lying on their application for this permit?
Not really right now, no.
And is there any remedy prescribed at all?
No, but I think a denial of the permit would be appropriate, but we're not allowed to do that. I guess they do take an oath before my clerks. I guess if the court wanted to pursue some type of perjury or false affidavit, we probably could pursue that, but unfortunately we've not gotten in the position to do that. We just deny the permit.
And I asked that question, Mr. Chairman, that what I don't want to do is I don't want people who go in good faith getting a permit saying, no, I have no history, and then something pops up from 33 years prior that they didn't really recognize as a, quote, crime, getting them in trouble. I don't want people to run afoul of that. I just, are there other, I would just, Mr. Chairman, and to the witness, I don't know what the framework is in similar analogous context to people falsifying their statements to get a permit or getting a privilege, and perhaps that's something we could address as a committee. I would certainly welcome your thoughts on how that ought to be addressed.
Thank you, Judge. Thank you very much for your time and for your perspective this morning. Mr. Bankhead, I see you hiding in the back row. I think this would be the right time for you to come up and cross the T's and dot the I's for us, if you would, on some of the issues that Mr. Lunsford touched on in his initial round of questioning of both the witness, actually of the author.
Thank you.
And what I'm feeling as we go on, not being versed in this, somewhat familiar, then of course we went from the original bill to the substitute. Now we have other issues that have popped up. To me, in the last hour and a half, this has gotten a lot more complicated than, frankly, I had anticipated. What I would really ask you to do, respectfully, is to tell me why.
It's complicated?
Well, why is it? I mean, I guess what I'm trying to figure out is, what is it, in order for us to get to where Representative Mills wants to go, what are the steps in the context of what Mr. Lunsford was referring to that we have to go through with regard to our friends in the federal government? Not that we necessarily have a burning desire to do so, because I can guarantee you we don't.
Right.
But that being said, we don't want to sacrifice, we don't want to waste a lot of time and a lot of effort and a lot of energy and then just get shot down. So I'd rather make it a productive effort than an unproductive one.
Thank you, Mr. Chairman. That letter, the GBI really doesn't have a position on this bill one way or the other. There are some issues, and I might be able to provide some history regarding Mr. Lunsford legislation with respect to AATS position on the concealed carry permit and the background check that was done. Now, it goes against what she was saying, but according to what ATF told us in that letter, there needed to be a fingerprint recheck on a concealed weapons permit in order to use that to buy a weapon without a background check.
And that is and I'm going to interrupt you not because I'm being rude. I just want to make sure that I've got clarity as we go along. And that is as per federal law or federal regulation or
right.
What?
That's Brady Act. That's federal law as far as, well, it's ATF's interpretation of it, too.
Well, now that's an important distinction.
I know, but it's in that letter.
Okay.
So
and Mrs. Harden, for members of the committee, Mrs. Harden is making copies so that we can all have a copy of it to review.
And I just got that fax a couple of minutes ago, and this
Okay.
issue was several years old, so I apologize for not being able to go through that letter.
No problem.
So, you know, if you want to go, like Mr. Knox said, then the fallback would be ATF possibly not allowing the purchase of a gun without a background check if you use your concealed weapon permit. That would be the only fallback that I'm aware of. And there would be issues possibly with the reciprocity. The Attorney General's office handles the reciprocity issue with other states, and they put out those announcements. But you know, if you don't want to,
let me ask members if they could, just to keep it down. If there's a conversation, just please take it outside because it's a small room. Thank you.
So if you don't want to go the route of getting federal approval, then the fallback would be they're saying that they won't allow a NICS check. I mean, they won't disallow a NICS check with a permit. So every time you buy a weapon, you would not be able to use your concealed weapons permit to get around the background check.
So it becomes a per weapon exercise?
Right. And that might be the best route to go. I mean, that's probably.
What are you in a position to render an opinion on ATF's opinion regarding their interpretation of?
I'm not. I'm sorry. I wish I could.
It's a pretty nice try of me, don't you think?
I mean, and if you read that letter, it might not be.
Has that been tested in any jurisdiction that you're
Not
aware
that
of?
I'm aware of, no. There hadn't been any issues that I'm aware of with respect to that. Also, the issue came up earlier about a consent form that would be, you know, for that person's life. And I checked with GCIC just now, and they said that shouldn't be an issue as long as the consent form clearly states that we have the permission to do a background check as long as you're, you know, won't.
That was the lifetime
Right.
conditional concept
Right.
as per Representative Setzler's original.
And the deputy director for
comment.
GCIC, Paul Hepner, said that shouldn't be a problem as long as that form clearly states that to be the case.
So it'd be a matter of the probate court simply following through with
Right.
that mandate.
Right. And
would that mandate have a cost? Do you know of? I mean, going forward, under that conditional,
Right.
every X number of years, that is simply a matter of an online check, correct?
Right. If they do the online.
Are not charged to do the NICS or the ICE. There's no charge.
Okay.
And as of February 1st, and this goes back, I was talking about Mr. Levitas, we're not accepting cards anymore. So everything has to be submitted to GCIC through the live scan system or the GAPS program. And so that, you know, the turnaround time, even though we have a backlog now with respect to the ink fingerprint cards that we have to check, we're working on trying to do away with that backlog and should be completed by sometime in May. So there shouldn't be an issue as far as the time frame, like I mentioned to Ms. Levitas earlier. His amendment goes back to the problem ATF had with the previous law about the issue with if a check is not completed in a certain amount of time or the weather knocks down the system within 24 hours, whatever the law said at that time, then you would go ahead and issue the gun or sell the gun to the person. Well, that's one of the problems ATF had with that earlier law. Because once you issue the gun and then it turns out to be a problem, then somebody has to go back and get that gun away from that individual. So that's a resource that, you know, falls back on either local law enforcement or ATF, I think, was doing it, or somebody else. So, I mean, if you want to do that, fine, but that definitely will cause a problem with ATF's approval. If in fact you're concerned with that issue, you might not be concerned with that issue. You don't want ATF's approval, then every time you buy a gun, you can't use the permit to forego the background check.
And this is my last point, and then I'll open up. That really does go back to this whole ATF approval issue. I'm not sitting here under the assumption that ATF approval is necessary. I'm not assuming that it's unnecessary. I really struggle with, and this is, I suppose, a matter of interpretation of the Brady Act as to what exactly is required and what is really not required. Is it truly required, or is it an interpretation of a vague statute or regulation that could go either way? And that's something that I sense that we would have to do just from a purely interpretive standpoint. Is I guess my question would be, and this goes back to the issue before, if the author's not here, if legislative council opined as to whether or not that is a requirement under the Brady Act, and we don't know the answer to that question, do we?
The Legislative Council may have gone to ATF with this bill. I don't know.
It seems to me that's a very operative question, right, and that really is something of a turning point on this issue as to what is truly required and what really isn't. I don't know the answer to that question, but I'm going to find out. I don't know if that letter will answer your question, but that was their explanation to our request regarding to their decision not to allow foregoing the background check with a gun permit. And I appreciate their posture. That being said, of course, we're going to study that independently and see if we agree with their interpretation. Ms. Benfield, then Mr. Knox.
Thank you. I want to follow up on some of the chairman's concerns, and I share them. How much of the ATF's ruling is it their personal interpretation versus what does the Brady Law actually state? And I hate to create more work for you, but I think it would be informative for the members of the committee if we could see the relevant provisions of the Brady Act. I have no idea how long it is, but we could then make an independent determination of how much of this is purely subjective and how much of this is clearly stated in the law. And I have a question about, I know the Supreme Court issued the Heller decision. I think that was the first time since 1934. Was it the Miller decision before that there had been any ruling from the highest court in the land on gun issues? And I know that didn't address the specific issues we're discussing. But I would be interested in knowing if there's any federal appellate decisions, y'all may know, addressing some of these processes for the background check. Are you aware of any judicial opinions in the 11th Circuit that might be informative, maybe? And if I may, I do have a question regarding the Brady law. My understanding is there is a check that's required, the NICS check, for licensed gun dealers. But I thought that check was not required for gun shows and private transactions. Representative Lunsford and I were having a debate, and he said, no, gun shows are required to do a check. Could you educate me on that issue, please?
I think the key question is license. It's my understanding that they do check. I remember when we were doing the checks, we had to increase staff when they had a gun show to handle all the calls we received when GCIC was doing those background checks. So, we were doing them when there were gun shows in Georgia.
So the Brady law does require gun show purchases to have a NICS background check, or is it only licensed dealers at gun shows that would be required?
I think it's licensed dealers, is my understanding.
Could there be an unlicensed dealer at a gun show?
They don't allow them in.
Okay, and what about private transactions? Is there a requirement for a
I don't
NICS?
think so. I'm not aware.
Okay, thank you.
Mr. Knox.
You're on the spot now, I know, and we're asking you stuff that probably shouldn't be asking you, but that doesn't keep us from asking them. Because I think we're asking you to give your opinion of the opinion of the ATF about the opinion of the Congress's opinion of what the Constitution requires as interpreted by the opinion of the Supreme Court of the United States. And I'm not sure whether any of us in here are competent to do that. But let me ask you about the Brady bill. Doesn't it only regulate commercial transactions that involve firearms because it comes under it's only applied under the Commerce Clause?
Well, it's my understanding it's between a sale between a licensed gun dealer and a private citizen, and that would include gun shows, in my opinion. We're not involved in that anymore, so I haven't really kept up with any of the changes.
Okay. So my question then would be, if it involves the issue of commercial transaction, not the right of contract between one individual and another individual who is a citizen of the state of Georgia. I don't think the Congress is regulating that yet. That being the case, it wouldn't have anything to do with this law wouldn't have anything to do with the commercial transaction, because all I'm doing is saying I want an application to own one. I'm not saying I want to even buy one. I want to be able to carry one. That's not a commercial transaction. That's a constitutional privilege that I have. So I'm really at a loss to understand why we need to submit this to ATF at all, because it doesn't involve them. Period. Because the only authority they have is through the provisions of the code with respect to the Commerce Clause, because that's how the Congress gets into the state and regulates things. So this is not a commercial transaction of any kind that we're talking about in this law. That would be another matter altogether. So why do we have to go to ATF to ask them whether or not a citizen in this state can have an application renewed or not for the permission to carry it on your person, not to own it, not to purchase it, just to carry it on your person?
You don't.
Okay.
It doesn't have any bearing whatsoever
Okay.
on the state law with respect to carrying on your person.
Okay.
The only bearing it has on is whether or not you think it's important for a concealed license permit holder to forego a background check when you purchase a gun. And that's it.
Okay, but only as far as a commercial transaction
Right.
is concerned.
Right.
I don't have to undergo a background check to buy a gun from my brother-in-law, or to own a gun, or to hold a gun. None of that. Okay.
Yeah.
Okay, and that's current law.
Mm-hmm.
Okay, so this still doesn't go to that issue, does it? I mean, it's still not okay. All right.
That's very helpful. Thank you.
Thank you.
Representative Bearden. I'm sorry.
Love you too much to let you escape like that. Hey, quick question. I'm just reading through this first time seeing this letter. It sounds like what it's saying is that we had a system in place that was an alternative that, or qualified as an alternative to the NICS check, but every 5 years, as long as we're doing the NICS check, we should be fine then, correct? Is that the way I'm interpreting this? Because that's the way it's reading to me.
Interpretation, we thought, the way we looked at it, is that you had to have a fingerprint check every 5 years. I am, because I understood you say it otherwise.
Kentucky actually went to the NICS renewal background check, and we challenged ATF when that came up back in the fall, and we were doing this hearing. And we actually talked to them, and their new policy, as long as we're doing the NICS check on renewal, then we are good and do not have to do the fingerprint on the renewal. But they first time have to go through the fingerprint background so that we have that history, and that the NICS would be valid on a renewal.
That apparently is the latest opinion. That letter.
It's 2005.
Right.
Okay. Mr. Chairman.
Yes, sir.
It might not be an issue at all.
Well, and that goes, and certainly allow Mr. Bearden to follow up. That goes to the issue where, this is where ATF was then, this is where ATF is now. It's a different administration.
Right.
I mean, let's just go ahead and state that. It is a different administration. That goes back to my issue of, not really an issue, but my concern about getting to a certain work product that we can all feel proud of, and then all of a sudden having the federal government, rightly or wrongly, exercise its discretion, rightly or wrongly. So, there may be a situation where it just has to be tested. It may be a situation where it just has to be tested. And if we get to that point, we get to that point. But that's what I'm trying to plow through myself in terms of where they are and when and on what issue. So I appreciate it.
I was just going to check if Mr. Stone was signed up to speak, because I'd like to ask him about that when he comes up. Okay.
Mr. Bankhead, thank you so much. Very helpful. Let me ask Mr. Stone to come up with GeorgiaCarry.org. Welcome.
Mr. Chairman. My name is Ed Stone. I'm the chairman of GeorgiaCarry.org. We were formed 2 years ago with 6 members. As of today, we have more than 3,600 members, and it's growing every day. We have several members here in the room. Just raise your hand if you're... And I see some are gone from the room now. And they're here because this bill is of great interest to them. These are people who carry every day, or who may be prohibited by some of the items that were discussed earlier from carrying every day. I just wanted to address quickly, there are a couple of different issues that have been talked about here this morning that seem to be conflated. First of all, I think Legislative Counsel, based on the representations that have been made today, may have made a mistake. Reciprocity and the NICS check are two different issues. Reciprocity is entirely state law. The federal government has nothing to do with reciprocity issues. Each state determines reciprocity for itself. I will give one example. Indiana, which has a lifetime license, Georgia recognizes Indiana's license. Indiana recognizes Georgia's license. That's because Georgia's reciprocity law says, basically, if you recognize our license, we will recognize your license. And therefore, any state that recognizes Georgia's license, Georgia recognizes theirs, and they can carry their firearms while they are here in Georgia. And it is important to say that that is carry. Unlike the majority of states in this country, Georgia requires a license even to carry a pistol openly, which most states do not do. And there's a very dark historical reason for why that's the case here, which I won't go into because it doesn't really deal with the issue here. But if you're not licensed in Georgia, for example, if you have the one marijuana seed conviction, even if it's a first offender plea where you pled guilty under first offender treatment, where you're advised at the plea hearing that you're going to get all your rights back after a year if you comply with the probation, you are nevertheless disarmed for life. So this is a very serious issue in this state because there are a number of people who are disarmed for life under misdemeanor convictions that don't pose any danger of violence to anybody, and that includes even driving in their car, because driving in the car requires that you be not enumerated as ineligible for the license, and people with a misdemeanor marijuana conviction are enumerated as ineligible and therefore cannot have it in the car under danger of being hit with a concealed carry arrest and conviction. I reviewed the letter from May of 2005 while I was sitting here, and the letter says nothing about fingerprinting. I just wanted to clear that up. Fingerprinting is not required even on the first application. Now, I understand there are reasons the state of Georgia may wish to do fingerprinting on the initial license application, but there is no good reason for doing it at renewal time. I wish to commend Representative Lunsford, he's no longer here, for having stepped in to fix the issue with NICS back in 2005-2006 when this issue arose. However, at the same time, I have a few soft criticisms to offer in that the bill, House Bill 1032 it was at the time, went a little too far, and that is by making fingerprinting a requirement at renewal time. This wasn't required to meet the ATF letter or the federal law. The federal law, by the way, is 18 U.S.C. 922 T3. And that's a very short provision. You can read it for yourself, but they set out on the front page of the ATF letter essentially what it is. The law of the state must provide that the permit is issued only after an authorized government official, that can be a probate judge, it can be the Secretary of State, it can be the Commissioner of the Department of Agriculture like it is down in Florida. Just an authorized government official has verified the information available to such official, and that information available you determine by putting it into the licensing law. You say what information is available to that state official, but it must include NICS check results. That is what the federal government cares about. Does not indicate that the possession of the firearm by the applicant would be in violation of federal, state, or local law. There's one more requirement in 18 U.S.C. 922 T3 that is not listed there in that letter, and that is that the license not be more than 5 years old. So while I would support an automatic renewal where the NICS check is just done automatically and the license stays good for a lifetime, unfortunately that would not meet the federal statute because the statute requires that the license be less than 5 years old. It doesn't say a check performed every 5 years. I had actually checked that this morning before I came here. I didn't actually anticipate I would need it, but that's what the license says. And because of that, I realize I can't propose any changes here, but I would ask that some representative take a careful look at the recent version of House Bill 155, page 5, starting on line 139. Where both has been struck out, just as it's been done for the fingerprinting checks in C and D1. But in D2, the NICS check, NICS, that's what this is here on line 142, National Instant Criminal Background Check System, has struck out both and requests for license renewals. That probably should not be done if you want this license to maintain the NICS exemption. Now, I want to clarify that the NICS exemption has nothing to do with whether a license is valid in a state. States determine that for themselves. You don't have to have a license at all. If you just wanted to repeal the concealed carry law, people could carry without a license. There are several states that do that, and as I noted earlier, the majority of states have no requirement for a license to carry openly, that is, if the weapon's not concealed. But to maintain the NICS check, that needs to be done at renewal time. It's an instant process. As Judge Brown testified, there's no cost for doing it. This is, for any of you who've actually purchased a firearm, this is what happens if you don't have a license and you purchase it and they go get on the phone or go to a terminal and come back in a few minutes and tell you you're either approved or denied. There are a number of people in Georgia who would like to maintain the NICS exemption, the reason being that like some bureaucracies, it gets problems in its system, and they have people who are put on indefinite holds. As an attorney, I've actually represented people who are put on an indefinite hold, and as long as you're on a hold, that is not a denial, they won't give you a reason, they won't permit an appeal. Now, the federal law states that the firearm can be sold after 3 days, but a lot of firearms dealers don't want to risk that once there's a hold, so they will not sell the firearm until that hold is cleared up. Meanwhile, the client sitting here in a position where he can't get it cleared up, they won't give him a reason and they won't permit an appeal. My advice in those cases has always been to go and apply for a license, because the probate judge takes a look at the background. If there's no issue, issues the license, and then they are exempt from that NICS check. So I do know that there is a constituency that will want to keep the NICS check, and I would ask that a representative look carefully at perhaps not making that change to 1611-129 D2 that's reflected in this current provision. There was several statements have been made on various issues, one of which was the concern over fraud. I just wanted to put these up here. One's a Georgia license, the other is my Utah license. The Utah license was applied for by mail. Most states, in fact, Georgia residents can apply to by mail and get a license. I'm not aware of any issues with fraud. You can do the same thing in Florida, New Hampshire, Rhode Island. Many states permit that. And I'm not aware of any issue with fraud. For one thing, when these forms come in the mail, the person would have to know something as private as, for example, the date of birth of the applicant, or those forms aren't going to go through when Judge Brown gets it with a wrong date of birth or a blank line on the date of birth. I'm not assuming she's just going to pop a license in the mail and say, here you go. So I don't know that will be an issue. As far as buying guns, which was the other issue raised, number one, you don't need a license to buy a gun, but if the concern is over somebody who has an NICS disqualifier purchasing a gun, you also have to show a picture ID when purchasing a gun. So you'd be presenting this license along with a driver's license. So now we have to have someone who not only knows the date of birth of the prior occupant of this house and has some felony conviction or other disqualifier under federal law, but also has managed to get a driver's license in their name as well, and now can present both of these to be exempt from the NICS check. The other issue I wish to address briefly was mental health checks. There were a number of things said regarding mental health checks from two government officials who've testified, and what you can do is just look at page 3, B1, which is lines 74 and 75. That first one was part of House Bill 1032, which was Representative Lunsford's bill to get back the NICS exemption. And that says any person who's prohibited from possessing firearms pursuant to 18 U.S.C. Section 922. These are the list of licensing exceptions. I'm sorry, I'm on page 3, lines 74 and 75. And in 18 U.S.C. 922, it's an extremely long bill. We should probably amend that at some point just to say 922G, which is where the disqualifiers are listed. But one disqualifier is if you have been involuntarily committed. That is not to be confused with B4 down at the bottom of the same page. I believe it's starting at line 91. Georgia is more restrictive than the federal law. Contrary to popular opinion, Georgia is a very restrictive licensing state. There are police officers who can carry a gun into this meeting room who are not eligible for a Georgia firearms license. That's not hypothetical, it's just fact. And but B4, the restriction that goes beyond federal law, doesn't have anything to do with involuntary commitment. That is any inpatient hospitalization for mental, alcohol, or drug treatment. In other words, if I were finding myself having to down 6 beers at night to unwind after work and go to sleep and decided this was a problem and check myself into a place to be treated, this is hypothetical, no, I don't do this, and no, I haven't done this. But this is a person who would be subject to this extra provision. This is an optional provision. Not all of the probate judges do this check. In fact, my understanding is the majority of them do not. And part of the reason for that is the DHR here in Georgia, as you know, there are some budgetary issues, and they are notoriously slow about responding to the requests. But essentially, this is a check on the form where people filling out the application might say, yes, I've been hospitalized as an inpatient for treatment for one of these 3 things, and the judge would then theoretically go down to the DHR after obtaining this waiver and a fee of $3 and forward those. And when the DHR gets around to it, they return the records check. Now, some probate judges are doing this as a matter of course, and those are some of the more notoriously slow probate judges around the state. But this is something that is an addition, and there is not, as was stated earlier, any discretion to issue to a person who has been involuntarily hospitalized. That is a clear disqualifier under B1. That was the first one that we pointed to. I wanted to limit my comments mainly to the bill that we have before us today. GCO would have supported the original lifetime licensing bill. However, as I see that that's not before us anymore, that licensing bill left in place the 5-year license. So if you wish to apply for the 5-year license, and some people would because they want to keep that NICS exemption, then things for them would have continued on just as before. However, it had an option for a lifetime license, which many people would have taken advantage of, knowing that after 5 years, it would not be eligible for the NICS exemption. It would be for 5 years, but after 5 years, it would lose it, and that it might affect reciprocity for that lifetime license only with some other states. But again, that would be an individual choice that individual Georgians who carry a firearm would make on their own. In fact, I didn't see any prohibition in the law on perhaps obtaining both. If you had concerns over problems with renewal, you'd have the lifetime license. If you had concerns over reciprocity or NICS, then the original 5-year renewable license would have still been available. With that having been said,
what is the issue about having the option there? Is there an issue with an option?
I don't believe so. That's how Indiana does it. Indiana permits, they've been doing that for several years, where you can get their original license, and of course no license is required in Indiana to carry openly, like the majority of states, unlike Georgia, but you can get either the lifetime or their renewable license in Indiana.
Mr. Franklin.
Thank you, Mr. Chairman. Something that you said about the 18 U.S.C. 922 T3 requiring the 5-year renewal. As you were listening to Representative Setzler's proposition of the presumptive lifetime application, is there, do you see a scenario where we could still do something like that but consider it an automatic renewal, that call it a 5-year license that's automatically renewed, and where you don't have to go renew it, it would automatically renew unless there is one of these problems that have been mentioned? Would that be in compliance if it was an automatic renewal?
Excuse me, Representative Franklin, it would be fine so long as the license were actually reissued rather than the same license. The distinction in the federal law isn't whether the check is performed every 5 years, which is, if there were any common sense in the way it was written, that is what it would say. However, 18 U.S.C. 922 T3 actually states that it must have been issued within the last 5 years.
Thank you.
So we're precluded. It's got to be 5 years.
If you want to maintain the NICS exemption, the
exemption,
license cannot be more than 5 years old. I believe that's why this new draft has been presented, not for reciprocity reasons, as Legislative Counsel might have said.
That's my understanding as well from the author's comments earlier.
I did want to make one statement about the Secretary of State. I understand that's outside of what this bill is here, but Georgia's the only state that uses probate judges to issue licenses. It's a statewide authority in every other state. In fact, the Utah license I showed a moment ago is a statewide authority, and they issue to foreigners, people from out of state. They don't have a residency requirement like Georgia does, which I believe is unconstitutional. In fact, we have a lawsuit that has a hearing in federal court on March 6th on that very issue. But the Secretary of State already uses the Georgia Applicant Processing Service to issue licenses to detectives, private investigators, and security guards who are armed in this state, and their license, in fact, permits them to carry right here into this meeting room. It permits them to carry into public gatherings and almost all of the areas that are off limits to the regular firearms license. So the Secretary of State is already doing these criminal background checks. She already has expertise in that area. It's set up by law, and that is what she does. I'm not suggesting necessarily it be done to this. I understand there was some hesitation about that, but I just wanted to clear that up. This wouldn't be something new for that particular statewide agency, and like I said, other agencies handle that in other states. In Utah, it's the BCI, Bureau of Criminal Investigation, I think is what they call it. In Florida, it's the Department of Agriculture. So different states do that through different entities, but there are many ways to get to those criminal background checks, and the Secretary of State does already do that.
Mr. Franklin, did you have any follow-up?
Yes, thank you. If back to my original point, if we put in the language that the probate court shall reissue automatically, and just they do their checks, and every 5 years, here comes your license in the mail. You don't have to go apply. You don't have to do anything. It just shows up. It has been issued. Would that comply?
I believe that would comply with the federal law on the NICS exemption, yes.
Thank you.
Ms. Benfield.
Thank you, and thank you for being here, Mr. Stone. I appreciate your educating us and your knowledge on these issues. I have a question on the Utah license versus the Georgia license that you held up. I saw the Utah license has a photo ID. Do you have any do you or your organization have any objections to requiring a photo ID on, say, the Georgia license to carry that would provide an additional check on this is, in fact, the person who has applied originally for the license when they go for a renewal?
Yeah, GeorgiaCarry.org does not have a position yet on photographs on the license. It would have some benefits, such as being able to use the license to vote, which is, in fact, up until 2 years ago, what you could do with the firearms license. The downside is, of course, one more thing that you have to go a hoop to jump through to exercise a fundamental right, and that is go get a passport quality photo to include with your license application.
If I can follow up on that, you said you're not, I do have some concerns with the fraud, and I think they're legitimate, and you said you're not aware of any issue of fraud, but that would be extremely difficult to track whether or not somebody has, in fact, fraudulently obtained a license to carry in another state that didn't have the same renewal process. But you said the application requires a date of birth. I do think that's something that could be fairly easily found through a internet search. But does the application also require a Social Security number? Is there other personal information that's required in that application that would cut down on the possibility of fraud?
There is other personal information, not Social Security numbers, however, because that's a violation of federal law, the Federal Privacy Act. But it does require other identifying information, height, weight, hair color, eye color, that sort of thing. but it does require date of birth, and I apologize if you thought I was accusing you of being insincere. You said you had sincere concerns, and I certainly was not contending that you were insincere. I was merely pointing out that there are some other issues, and the concern about buying a firearm, of course, you do have to present a picture ID when purchasing a gun, even if you have a firearms license.
Would you have an objection? Can I ask another follow-up? Would you have an objection to the renewal process requiring the person to come in and show a photo ID and do away with the fingerprint requirement on the renewal, understanding that you had that on file and that would remain on file? But would you have an objection to simply having to come in as the probate judge testified, hopefully just requiring a 8 to 10 minute process, is I think what you testified to? Show the photo ID, ascertain this is in fact the person, and then the license renewal could actually be sent by mail to cut down on the number of trips. Would you have an objection just to that photo ID check?
That would be better than the law we have now, which is that you have to go to the sheriff's department or the GAP system and get fingerprinted and all of this other stuff. In fact, it's basically an initial application all over again every time you go in to apply, which is what happened when House Bill 1032 was passed. However, I would object to it as frankly unnecessary. This is yet one more hoop to jump through to exercise a fundamental civil right, and you have to go to a building where you're forced to disarm, and technically under Georgia law it's a public gathering, so you cannot carry to or while at, and there is case law saying that means you cannot have a firearm in the parking lot adjacent to a public gathering and off premises up to 200 yards away where the firearm is available for you to go and retrieve it in the case it is needed. And the public gathering law, I've testified to the Senate Firearms Committee, obviously, that is something that needs to go from our law. It's an anachronism. Georgia is the only state in the nation that has such a law, but that law comes into play every time you go down to the probate court to apply for a firearms license, of all things. And having it done by mail would permit people to be able to apply, as I did with my Utah license, without having to disarm and go down to the probate court.
Mr. Sessler. We need to keep moving. Mr. Sessler.
Thank you, Mr. Chairman. Representative Benfield, maybe I'll ask you a question and we can get it answered. What I have over the course of this testimony today become concerned about non-felony conditions that prohibit someone from getting a permit to carry. Can you enumerate for us those non-felony charges or conditions that would prohibit someone from getting a license?
No, I can enumerate several of them, but it gets pretty broad.
And if you could help us kind of draw a distinction between those which are prescribed only in Georgia law and those are required under federal law. I know Lautenberg is pretty expansive in terms of what it reaches down.
Yes, federal law has, of course, felonies and misdemeanor domestic violence convictions.
So under federal law, it's just misdemeanor domestic violence. That's the
only misdemeanor under federal law.
Okay.
And felonies, and then of course there's the involuntary hospitalization, and those are all covered by B1 and state law. Essentially, everything else after that is something that is Georgia specific. The inherently evil act of parking in the probate judge's parking lot with a firearm in your glove box is something that would disqualify you from having a firearms license.
Ever?
If you look in not ever. If you look in B2, you'll see. I'm sorry, page 3, lines 78, 79, and 80. People against whom proceedings are pending, and it lists some code sections there. 1611-126 is concealed carry. 1611-127 is the public gathering law. That is what I was referring to earlier. And 1611-128 is carrying a firearm openly without a license. We actually had a member who was arrested unjustifiably with a license for concealed carry, code section 1611-126, when he was quite obviously carrying openly. Those charges were eventually dropped when we retained a lawyer for him, and we're now suing the deputies that made that arrest. But during the time before the charges were dropped, his license expired, and he was not eligible for a renewal because he had an arrest with proceedings pending under 1611-126, which is carrying a concealed weapon without a license. And as you continue on down, a rather large one on the next page has been mentioned several times. B5, it's on page 4, starting at line, I think that's 106. It's cut off on the left-hand side of mine. B5. Drugs are treated very differently in Georgia law, and just about every drug offense other than misdemeanor marijuana possession is a felony. So that's going to be a disqualifier under federal law regardless. If you struck this entire section, and you can see it's rather long and convoluted, if you struck that entire section from the code, you would still not be able to obtain a firearms license for almost every drug charge that exists in the Georgia Code.
Okay.
However, this also disarms first offender pleas for misdemeanor marijuana convictions, and that includes people who are 17 years old, which is an adult in Georgia, who've had not even so much as a speeding ticket at the age of 65, who still can't get a license.
So, if again, I guess to draw that discussion to closure, could you make available to me or some other members of the committee at some point in this process sort of a list of non-felony conditions in Georgia that could be considered potentially as this bill moves through the process, potentially for amendment? We don't need to talk about it. I know the chairman's sensitive to time, but I would like to have access to that as we move through the process. One last,
I'd be happy
Mr.
to
Chairman,
do that.
if I could. You spoke to the provisions of again the folks hospitalized as an inpatient in mental institutions. Could you compare for us our statute in Georgia versus other states? Do other states require some kind of adjudication or finding or diagnosis by a mental health professional as someone being not able to carry a firearm versus just the presence in the facility? And I asked that question. I've got a neighbor that's dealt with depression in the past, and there are issues about checking themselves into a facility. Otherwise, an upstanding member of society, but just needed to get their meds right and those kinds of things. And I, at face value, wouldn't see this person as a candidate for being turned down for permit to carry, because it's really just an issue of managing med levels with a chemical imbalance. So I'm sensitive to someone checking into a facility versus someone being ruled by a psychiatrist as not being fit to carry a firearm. Where are we very quickly? Where are we relative to other states, and where might we be?
Well, I have to admit that I have not made a thorough survey of that. I know that different state laws are different. Each state sets up their own, as long as it does not. Even then, a state can issue a license to anybody they want, even people who have been involuntarily committed. They just lose the NICS exemption, for example. Virginia issues licenses to people who've been convicted of misdemeanor domestic violence. They just don't have the NICS exemption.
So for the NICS exemption, federal law draws the line at involuntary?
At involuntary commitment, yes.
Okay.
Yes.
Thank you.
That's in 18 U.S.C. 922G, by the way. You can read those. It's a pretty clear list of exclusions.
Mr. Stone, thank you.
Thank you.
Appreciate your perspective on this issue. We'll, I think what we'll do, we have one more witness. I think I'd like to go ahead and hear that witness, and then we'll wrap it up on 155, and that's DJ Beard with Georgians for Gun Safety. I'm sorry, there is one other witness afterwards, Mr. Ross, if Mr. Ross would like to go ahead and speak on it.
Hi, I'm DJ Beard. I'm on the board of Georgians for Gun Safety, and Alice Johnson is our expert, and she's not able to be here. But we're a really small group, and our main concern is safety in the community. And this is so complicated. It's amazing how so many things are opened up when we look at all these pieces of this bill. And I didn't have a chance to really read the substitute yet. But we are really concerned about keeping people safe. And firearms, just in their nature, are things that can harm people really fast and really quickly, and there is a right. We do agree with the Second Amendment. There is a right to bear arms, but we also, because of the nature of firearms nowadays, we think there should be reasonable restrictions and a lot more record keeping possibly than we already do. We do have, Alice had found that Utah actually keeps, I have extra copies here, they keep statistics on revocations, and apparently they have some system they started in 2000 that apparently the revocations went way up when they started checking arrest records on a daily basis. And in 2000, you can sort of see on the graph, but it went up from 75 to 256 from one year to the next. So we think Georgia might, that would be another thing to investigate. That what do we do when arrests happen, and is there a way to revoke the licenses? Of course, when we originally came today, we thought that this was going to be a lifetime permit, and there would be no opportunity to review each person's record. But since we have the 5-year limitation, then we're fine with that, of course. But our main concern has always been just to keep people as safe as possible and support law enforcement in what they do. And we don't really believe that law enforcement needs to be confused, especially in public gatherings, with too many people with guns and not knowing who's the criminal and who's the defender, those sorts of situations in the public gathering situation, which I know that's not what we're discussing, but Mr. Stone had brought that up. And the 30-day requirement also, we know there's a lot of issues with the FBI information taking so long, but we really believe that's very important information, and we wouldn't want to limit that sort of thing. We would want all available information to be considered before someone got a license. So
thank you, Ms. Beard. Questions for Ms. Beard? Mr. Bearden.
Go ahead, sir. I'm trying to find something real quick.
Ms. Benfield.
I just have one question. It may be more appropriate for Judge Brown, but I don't see her here. Okay. And you were referring the Utah, and I believe you said they do arrest record checks on a daily basis, which is a phenomenal feat. My question is, in Georgia, how are felony convictions flagged, if at all? Under current law, let's say somebody the day after they get their license to carry commits a felony offense or a misdemeanor domestic violence or a commitment in a involuntary commitment in a mental health institution or any of the other prohibitors. Would they be flagged prior to 4 years and 364 days later?
Well, I don't know. We have a lot of questions about that. I don't know if they're flagged on. I know someone brought that up. Whether they're flagged on indictment or do they get flagged right away with the arrest? I don't really know that. I guess I don't know if Mr. Bankhead's here.
Yeah, I was thinking Mr. Bankhead may.
You might know that.
Mr. Stone may know. Do you know?
We could find out.
That would require each arresting agency
to report. And there's no centralized database among the probate judges, so there's really no good way of communicating if an offense occurred in another jurisdiction.
Exactly. Yeah, there's a lot of issues in our state, I think, with record keeping in general.
Yeah.
And I think that we could address that a little bit better.
Thank you.
Thank you, Mr. Bearden.
Yes, ma'am. You brought up safety. I'm just looking at CDC's website. You know what what's the top 5 causes for injuries to children?
Oh, I know it's not guns.
No, it goes road crashes, drowning, so pools. So we should outlaw the pools, burns, falls, and poisoning.
Well, see, we're not for outlawing guns either. We never said that.
But it's about safety, though, so we want to make sure everything's safe.
And there are rules about fences around pools and that sort of thing, which are reasonable. So I think the same applies to guns.
But it's safe to say, though, by CDC standards, guns are not even in the top 5 causes of death for kids.
But if anybody's ever had it happen to them, I think they would be pretty concerned.
As a former officer and worked many things, I'm familiar with it. But safely to say, under CDC's, the top 5 list does not include guns.
I know, but
Thank
we need
you.
to make every effort we can. That's just my point.
Thank you, Mr. Bearden. Mr. Knox.
Let me ask you a question. What is it about an application renewal, which is what this is about, renewal of a license, that makes it safer for children, makes children safer in connection with guns?
I don't think we can really relate the two. I mean, I think this is all about renewing the license to carry a concealed weapon in the home. There's a whole lot of issues about children and
okay,
how
well,
those are stored.
let me be more precise. And what is it about renewal of a license for the permit to carry a concealed weapon that makes children safer? Compliance with that law. How does that make children safer?
I think it just keeps the community in general safer to renew every 5 years, because there's opportunity for things to be discovered that could have happened within those 5 years that were not there before. Because human beings are human beings and things can happen.
Okay, well, let me ask you this. Do you think that that if somebody decides they're going to hold up a bank, that one of their main consideration is going to be whether or not their gun permit has been renewed or not?
No, I agree with that. You're right. The majority of people who have concealed weapons permits, the huge majority probably, has never done anything like that. I agree with that. But there's always a chance that something could have happened in their life within that 5 years that could have caused them to do something.
Well, I mean, a lot of things can happen. There's always a chance of something, anything happening. Eventually this is all going to come to an end anyhow. But that's a big chance that we take living here.
Well, sure. But I just think that guns, in and of their nature, they're just such a quick, fast way of injuring and killing people that I just think we need to be more careful with them than we are with some other things, possibly.
Thank you. Ms. Beard, thank you so much.
You're welcome.
For taking the time to be here this morning. Our final witness is Mr. Robert Ross, if he's still here. Robert Ross. Going once, twice. I think what we'll do is this. That concludes the testimony on 155. Members of the committee, I think what we're going to do, first on 155, I think we're well served to go ahead and consult with the author to see how he wants to go ahead and proceed. There are various issues that have come up today that are not necessarily directly related to this issue, but they could be in the context of an overall substitute. And I want to defer to the author, at least initially, on how he wants to proceed going forward. I have every intention of going forward, but I do want to consult with the author about that. I would strongly recommend and suggest that the folks who have testified here today consult with the author to see check with him on the breadth of how far he wants to take this, because there is a comprehensive way to address several issues here that have been brought up. That is a larger task, to be sure. This bill could be narrowed, or it could be broadened. I think it's my sense is that there are several members who would like to see the subject matter of the bill broadened. I think we have to defer to the author on that, and if those other issues are going to be taken up, perhaps they'd be taken up in the context of a study over the interim in preparation for the second year of the 2-year term. So I think that's what we'll do going forward. But again, I'd recommend that folks who have testified here today, including Mr. Stone, consult with Representative Mills, and I think it's important to have consensus going forward on a bill like this as to what the parameters are and are not. I know I'm going to go ahead and review very carefully what it is what makes the most sense going forward on as it relates to the NAICS test or requirements as per federal law. And we talked about the possibility of an option for those citizens who wanted to maintain compliance on that portion or have the option of not, depending on what it is they wanted to do, understanding full well that it has to be that 5-year license as opposed to the lifetime, and we're constrained by that, and I don't think there's anything we can do about it. And once we go ahead and have that conversation, then we'll plan another hearing and potentially another substitute for markup. With regard to 182, Representative Austin, you've been very, very patient. I think what we're going to do is this, and I apologize to you. We didn't anticipate this going as long as it did. There is another subcommittee that is here at 1:30. What I would like to do, with your permission, is to hold your bill until Friday. And we will go ahead and meet on the next recess day on Friday morning at 9 or 9:30. I will tell members that we're going to meet every day this week. We're getting right up on that time where we have to meet every morning. But again, that will be for no more than an hour and a half on Tuesday to Thursday. And then on Friday, we'll open up with Representative Austin's bill. And I apologize for any inconvenience, and we'll see to it that certain administrative things occur regarding your time here today. Is there any further business from any members of the committee? With that, we're adjourned until tomorrow morning at 9 o'clock, where we'll take up the markup on House Bill 123. Tomorrow morning at 9 o'clock for the markup on 123. Thank you.